in this case. May allow to go on bail of 30,000 with one security of the like amount each to the satisfaction of the arresting authority. And subject to the conditions that they shall appear before the learned court bill on the next and subsequent dates. Next, they shall be available for trial. They shall not hamper or tamper with evidence. They shall not harm or harass the informant side in any manner. The petition stands allowed and disposed of on aforesaid terms.
Lordship, Chief Judicial Magistrate Dhubri.
Yes, concerned learned court,
Not Lordship.
not Salmar.
No, Lordship.
Oh.
Dhubri.
Oh, at that time it was.
Lordship.
No, it was. I
Page
saw
25, Lordship, summon from Dhubri.
Fakirganj, right? Fakirganj space. Fakirganj is in Dhubri.
Yes.
Yes. Dhubri. CJM Dhubri. Fakirganj is in Dhubri.
Bail hearing BA 22.
Otago will go like that only, because councils have some difficulties. It seems. Bail hearing, BA hearing, then AB hearing.
May please, Lordship. Because this Lordship, charge sheeted metal, Lordship, commercial quantity, Lordship. Lordship, in this case, Lordship, there are 5 accused persons, Lordship, total. Against one absconder charge sheet was filed and another 3 was granted bail by
Okay.
your
He
Lordship.
is similarly placed, Basant Thak.
Yes, Lordship.
Okay.
Similarly placed to Sakidul, Lordship.
Sakidun.
Because Basant Thakur's possession, nothing has been recovered.
I think we granted him bail on the 47, right?
Yes,
48 months.
And other 2 accused also, Lordship, was granted
Please check it, or do we need to check it from here? This, who's appearing for the other side? Oh, that's a NCB, right? Okay, relax. We are seeking bail on the basis of parity. Do we need to see the record which has come?
Lordship,
Yes.
please, your Lordship. Mr. KL is out of station.
Yes, yes.
Can the matter be fixed another date? Because Lordship, I cannot make the submission as Mr. KL is still standing counsel.
Other 2 accused person.
Yeah, that's true. It's okay. We can fix it another day, but just we have to see from here, right?
Yes, your Lordship.
When will you be back?
He'll be back on 8th of December.
8th of December.
Lordship, at least interim Lordship at this stage, because all other are released on bail, Lordship. Mohammed
I will
Nusrati
look
was,
into that aspect. I will look into that aspect. Kindly do me a favor. You just we'll take it up after some time if necessary. Okay, we'll consider that adjournment. You can just to save time, just see and you can mark that copy. And just because it is our duty to tell it. This must be the one, but our duty we have to tell. Our duty, my duty. And you are fully capable of submitting. But it's a procedural for department. It's another matter. So I respect that. But you just check, then we'll see. Usually these matters, interim is not granted, but in this peculiar situation, let's see. If I am the record, the notice is fine, then maybe we can consider it, after some time.
if you bless me.
What is 11? Admission, both person.
23.
Both with us admission, no? Very nice, bail, so now, bail.
23 and 33 same.
23 and 33.
23 and 33 same thing.
$33 is AB.
AB. Husband and wife.
Oh, I see. So,
After some.
plus 23 and 33 again like this one box. No, okay, I get that. None is appear.
$24.
Yes, Mr.
May please, your Lordship. Mallet, he is in jail since 29 days, Mallet, today, and FIR is plus 9 now.
That's still on.
But The informant is a my lord Latmundo filed this affair. With due respect, beg to state that I am a third grade.
Page
working-
number 9.
Page 9, man.
Okay. Mhm.
On 25/10/2025, the noted accused, that is owner of the number of mobile number so and so of mobile phone, asked me by representing himself as a Chief Minister Vigilance Cell to give minimum rupees 1 lakh to his phone pay account and inform over telephone to pay more thereafter. Otherwise, the accused caution to harm a lords and thereby disturbing our family members mentally. And next, my lord, here not mentioned the money was given or not. In forwarding report, my lord, that is page, my lord, 15. My lord, accused persons were arrested on the following ground of arrest, my lord, in number 2 ground, my lord. That sir, accused by dishonesty, inducement and criminal intimidation compelled the complainant to transfer an amount to rupees 50,000 through the phone pay,
Mhm.
thereby committing an act of extortion. Well, in the FIR, he's saying that the present petitioner demanded 1 lakh rupees, saying that he is a vigilance of Chief Minister office. And in forwarding report, said that already he paid 50,000 in phone pay. Actually, my lord, he paid 50,000 on phone pay. They are very much, my lord, known person. And that money was, my lord, for other purpose, because it was had to given to the present petitioner. And my lord, he some way money has given, but in the affair did not disclose this facts, my lord. The money already paid. And it was the, my lord, loan money, my lord. And he's saying that I do not know that person. He knows everything, my lord. So already, my lord, he is in behind the bar to 30 days. A person, my lord, how the money has given, my lord, without filing the FIR. If anybody say, my lord, that I am so and so,
Should never believe this thing.
yes.
Anyway, but the people do believe.
My lord.
The gullibility is there.
My lord.
Educated people.
My lord, here I have received the case diary, my lord. From the case diary, it reveals that 50,000 rupees already paid, my lord. And he is written in the name of my lord, CM Vigilance Cell, my lord. And on the pretext, he has demanded 1 lakh rupees and 50,000 already paid. My lord. And I was collected, my lord, sufficient material, my lord. It is not the fit case to grant him at this stage, my lord.
Is it?
Other witnesses also submitted that he, from his using mobile phone, my lord, he has paid 50,000 rupees, my lord, to the accused person,
Other people also.
my lord.
I think let the investigation go for some time then.
My lord, what happened? The person who gave the money, my lord, he very much known to this person, my lord, but he suppressed the facts in FIR. And it was not the money of extortion money. Very unfortunate.
That will be contradictory,
Right.
obviously,
If-
because if a
if-
person is known,
Eh,
he will know whether he represents,
eh, well,
he is from CM's vigilance or not, he'll know.
Fine.
Yes, my lord, if my lord, a Latmundal is known person, my lord, how he will give, my lord, without inquiry, my lord, in phone pay 50,000? What is his liability, my lord? He's not giving.
I mean, but learned additional PP has found some material.
My lord, kindly examine the nature of the affair, my lord. If any person, suppose a phone call come to me and immediately I pay the money,
That is our
And
story,
in-
their story.
in FIR
Their
also not-
story, but from the
but in FIR also not disclosed how he paid the
not
money.
necessary to disclose all that.
Subsequently, my lord, in forwarding report, police has found.
There
So,
is
my
an
lord, it is
investigation.
a case of bail, already 1 month he is in jail, my lord, regular bail, my lord. And all section is valuable except one section, my lord, is non-valuable, my lord. External will not come here, my lord. So sufficient time he is in jail, my lord, and police also taken custody for 5 days. And police custody also not
Yes,
required at present, my lord.
And Uddin, learned counsel, and the invoking 483, I'll just have a look, the 483 BNSS. The petitioner is seeking regular bail in connection with Tarabari PS 56 of 25 under so and so section. It's stated to have been arrested on.
As, my lord,
Can you help me with the date?
3/11, my lord.
3/11/2025. The on FIR dated 29/10/25 was lost by what is the name of the informant?
My lord, informant name is here,
Mustaq
on Mustaq
Mustaq MD
MD
Akram,
Akram.
with the allegation that that with the allegation that the owner of mobile number 94354 asked for rupees 1 lakh from him, representing himself to be from the CM Vigilance Cell. Also. Stuff. The learned counsel has drawn my attention to the forwarding report, in which it is stated that the informant was compelled to transfer rupees 50,000 by phone pay, contending that the same was not mentioned in the FIR. It is submitted that the petitioner has spent sufficient time in custody, and out of which he has also been in remand, police remand for 3 days, 2 days,
5 days.
5 days, 5 days. Sir. The case diary has been received. The learned additional PP submits that the investigation has found force in the allegations, and that the transfer of the amount of rupees 50,000 has been confirmed by the investigation, and that such transfers has been found with regard to other persons also. The petitioner counsel submits that the allegation is false, as the informant knows the identity of the accused person. The IO has also submitted a bail objection, and I perused the same.
Accused also admitted in his payment.
Yes, I have also admitted in my petition that it is a money of land management.
No, that is not admitted that he is
No, I have-
demanded rupees.
On oath, I have admitted in my petition that yes, money gave me. But it is not the extortion money. I had to get from him, but he tactfully lost the affair.
I find force in the contention of the IO in the bail objection, as well as the submission of the learned additional PP, that perhaps at this stage, the interest of investigation may be in refusing bail. In such view of the matter, the bail petition stands rejected at this stage. Return back the case diary. After some time, we'll see. Just sometime, next round maybe. Let the investigation progress a bit.
I'm blessed.
Because these are very bad activities.
Number 52, supplementary.
Here, no? 52. Yes.
On the case, part
Did you?
last time we.
Part is.
Part is lawsuit
Part heard, my lord, matter may kindly be time being, my lord. I will take instruction.
What was the matter? Part.
Lordship had heard it on the last occasion on Friday. This contraband, my lord, commercial quantity of contraband was found in the front yard of the petitioner's house. my
I
lord.
see.
So
So
that
plenty of time that way. After some time,
After some time, after some.
scan record is come.
Records are there.
53,
53, it will again it is down 53, and that's another connect. Towards that.
53,
10.
54,
Matter, my lord, it is behind the bar for, my lord, more than 6 months, my lord.
6 months.
My lord, private response is there, my lord, we have taken steps on.
But the service report is awaited, my lord. We will have to take instruction, my lord, regarding the service matter.
Okay, kindly take it expeditiously.
My lord,
Since it's
my lord.
to be for some time.
My lord,
Record-
takes on day after tomorrow, my lord.
Record is received, scan record is received. However, uh, service report is awaited. The prosecution shall take instructions regarding service. The accused is stated to be in untrial detention since 28/5/2025. This is the matter. Day after tomorrow. 3/12. Left.
55.
For 83 application, could I take your lordship page 13, that is the FIR, kindly. Matter came earlier also before your lordship, my lord.
Is it?
Page 13. It is,
Case diary not received.
I am let me submit. It is respectfully submitted that on 11/9/25, about 10:45 PM. If I parked my car near my friend's residence at Nandan Nagar, Barbari, and stayed there for the night. Today morning at about 4:30 AM, I came to know that my car has been missing from the place where I parked it. I searched the nearby, but I have not found something. This is the affair, my lord. A case that was registered under section, my lord, 316, that is breach of trust. Then, my lord, come to the forwarding, my lord, kindly forwarding, page 16, my lord. Quite different thing, my lord. During the preliminary investigation, Vishwajit Devnath of Dispur PS found that one Devojit Bhattacharya made an agreement with the fraudulent taken away the Maruti car, economic such and such, glittering grey number, dated such and such, of Hangarabari approached him under pretext of providing various work opportunities. Devojit Bhattacharya offered the complaint dated as such and such one vehicle is urgent and need for a monthly rent under the school purpose, and he has promised to the Biju Gankhua a payment of rupees 30,000 per month. After that day, the accused did not respond to the call. Then, my lord, during investigation, it is found that there is a huge nexus, fraud and cheating is going on where the group of accused made for different victims in the trap to give their vehicle in monthly rent basis and self-driver purpose, but for this wrongful gain, the accused illegally sold these vehicles at Manipur and Nagaland. That's our accused Deep Roy, already arrested in connection with the dispute PS case number 6939 under section 12. But your lordship has granted me bail, my lord, in this case. And my lord, thereafter, my lord, before releasing, immediately I was taken into again, told me arrested on 28/9/25. Total, I am 64 days behind the bar. So, my lord, I may be released on bail. That there is no similarity of the FIR and the forwarding report. What is this?
During investigation.
Yes.
Anyway,
In this case,
Nothing
it's
but a-
arrested on 6/11/25, madam.
charge sheet submitted.
No, such
No charge
submitted, madam. This is otherwise, madam, allegations are serious. I will have to get them.
No, what allegations did I against me? Is there reflects anything
Wait,
against
wait,
me?
Who are, this person is
I am Deep Roy. my
Deep
lord.
Roy. Deep Roy.
Deep Roy. Since I was arrested in another
Just,
case,
just let
earlier
me
I was granted
understand.
bail.
Devojit Bhattacharya, so and
Yes.
so. During investigation, he is next to some. Was taken.
Whole allegation is Devojit Bhattacharya.
They are alleged to be, I mean, that's the allegation. They're
Yes.
working together.
Yes.
So he was, Deep Roy was, Devojit Bhattacharya was also arrested, perhaps.
No, they were not arrested.
They were not arrested.
Yes.
So anyway, Deep Roy was arrested in another case, he got bail.
He got bail.
So in this case, he was arrested.
He was shown arrested, my lord.
He
Your
was-
lordship of the judgment of the apex court, but all the cases have to be shown where I am required.
Yes.
They have not done it.
Yes.
And I 64 days my card, liberty has been granted.
Apparently, madam, initially.
And that allegation,
the
yes,
vehicles
no
and
doubt.
thereafter sold it to Nagaland.
So
and-
people are also gullible to believe these things. with
I'm at
different
406, my lord.
unknown
Period
people,
60 days.
making agreements with unknown people anyway.
Yes.
But that is there, that is another aspect. But thing is that what is to be, this charge sheet is not submitted.
Not fine, not nothing.
Your lordship may kindly fix the day after tomorrow. I'll get.
No, it is being
This
fixed
could-
day after every day.
this
They are-
could be-
It was fixed on Saturday. Friday. See, your lordship asked my friend to intimate, but she got the information, it was not charged sheet. That's why it was fixed at 2 PM, but because of the positive time, your lordship could not take it and fixed it today.
Achha, otherwise, as far as the present sections, statutory period is over.
No, madam, here in this case, he was shown arrested on 6/11.
No.
Yes, 6/11.
Yes, 6/11.
It will come from, no, then it will not be, then it will not be over
No,
in this
no.
case. Anyway, Don't you think we, like instructions or case diary?
No case diary, my lord.
Case diary, get the
yes.
case diary.
The case that they have not produced today also. It was not produced on Friday also, madam. You see, all that was see from order sheet. It was
This
fixed
time
on-
I will get
at
it,
2
madam.
p.m. It
I'll
was fixed. Let him to take the instruction at 2 p.m. madam.
No, my lord.
The,
If they go on implicating me one after another, my lord, then what is my liberty?
actually, okay, allegations are also very serious.
But 420 allegation is that not against me, not against me, my lord.
It may be common intention, it may be anything, it has to be seen. definitely. But just see this thing, that's why I was thinking, if the statutory period is over, then it has to be kept in mind. So it's shown arrested on 6/11. I'll record, don't know. C. Biswas, Learned Counsel.
That is, my lord, they are in the
Get the
first page of the petition, my lord, index, my lord.
petitioner,
112.
he has a grievance also, so get
yes.
the CD
Yes, yes.
this time and tell the IO that
Yes,
the
madam. One
court is
last,
seeking.
your lordship
get
may
it.
record it as last opportunity.
No, I don't prefer because it otherwise, see, the thing is that suppose I record, can I dispose it of without the CD?
Yes.
Without, because these things create problems, so we must get the CD.
Yes.
But again, without delaying them also,
Yes.
because that is also a legitimate grievance. Whatever, irrespective of the outcome, he has a right for the bail to be
Yes.
decided.
Your lordship may fix it on 4th.
No, let it be tomorrow. Dispute, my lord.
Third, let it be on third. The case diary is not yet received, full stop. It appears that the present accused was shown arrested in this case on 6/11/2025. The learned petitioner counsel, Mr. Biswas, submits that he was also arrested
Originally
earlier
arrested at
in
28,
dispute
9,
PS
25.
case number 886 of 2025. No, he was shown arrested earlier in this, no? Dispute PS.
Case you thrown arrested. Earlier he was arrested regularly.
Sorry, dispute PS is this case, huh? This case. He was earlier arrested in another case, but was granted bail by this court. The petitioner side denies the allegations and submits that there is a dichotomy between the allegations in the FIR and the narration in the forwarding report. The case diary shall be procured expeditiously without delay. And the prosecution may also, prosecution is also at liberty to take instructions regarding the up-to-date status of investigation. Huh? This is the matter. Day after tomorrow would be more realistic. Instructions, I'll have CD, list the matter on 3/12. Okay.
There may be 25. May I please your lordship? I'm on interim matter, case diary was confirmed.
What is the matter otherwise?
Matter regarding the purchase of a Bolero pickup, my lord, through
What?
finance, my lord. I am not the FIR name accused, my lord. That one person is Sanjeev, he has been arrested on 13/2/25, my lord.
No, what
And I was the grantor, my lord. Yes,
What
I
is
can
the
grant that.
offense then?
Yes. So I am.
And for independence, receiving an incomplete. Fraud, that's just.
Yes, ma'am.
In this regard,
Allegation against one.
Process the said. So. It has a civil dimension, but it may also have a criminal dimension also.
Yes.
If there is
Yes.
fraudulent intention from the beginning, any case. Okay, yeah. He must have appeared.
I have appeared, my lord.
What is the revelation? in the
Earlier interim-
Investigation.
Yes, sir. Earlier, my lord, interim bill granted to the petitioner on 22/25. That order is available in the case diary, but regarding his appearance, my lord, and his statement, nothing is available in the case diary.
According to your instruction, he has appeared.
Yes, he have appeared.
He was. 20 long back he was given.
Yes.
Long back.
Otherwise, interim order
long back, should
Bail
have been available,
in the city. But
should have been available,
bail bond, my lord, his statement.
nothing.
nothing,
His
only-
statement is not there.
Not there,
Ap-
only the, my lord, order granting interim protection
Oh.
is there. There.
He has appeared,
Yes, his statement may be recorded that he appeared before the IO.
yeah,
According to his.
that is his instruction.
He's appeared, he's told.
As per his instruction, he has appeared.
Yes.
He's a panda of Kamaikha Ram, man.
Hmm?
He's a panda actually, by profession.
Never, it's okay.
So,
Whatever if he has told you that, so that's your submission, instruction.
he is still only grantor, my lord, that's
Huh?
that is the apprehension, man.
Huh?
He was grantor, my lord.
Guarantor.
Yes, my lord.
No, I mean, only guarantor will, it cannot attract criminality, but this allegation seem to be that
Since he has
some
been
fraudulent
arrested.
activities and, but otherwise,
Yes, my lord.
I think rightly granted interim otherwise, but it's a long time, it should be
My lord.
disposed of, right? So the case diary has been received, but it is submitted that by the prosecution that the statement of the petitioner is not available. The learned petitioner counsel submits that as per his instruction, the petitioner has appeared before the IO as per pursuant to grant of interim bail. Stop. So we will return back the case diary.
Yes, ma'am, I will come.
The case diary may be returned back and should I give a fresh direction for appearance? But if he
Yes,
has,
my lord, yeah. If he has not appeared, let him appear with,
the case diary may be returned back and procured again with the up-to-date status of investigation. And
otherwise, your lordship may also dispose it of directing him to appear before the, my lord, IO within a period of 10 days for recording his statement, ma'am. If he has not.
dispose it of also.
Your lordship may.
The present petitioner, the gist of the allegations in the FIR is about one person, Sanjeev Atpadia, taking loan from Mahindra Finance. And there's allegation of fraudulent activities with regard to the same, including defaulting in paying payment of the loan. The present petitioner is stated to be the guarantor of the said loan, which is also mentioned in the order dated Bis Dui 2025. You're right. This should be disposed of, right? Should dispose it of. Then we make it absolute. Heard both sides. Considering the long pendency of this petition, the interim bail is granted, is hereby made absolute. Interim granted by 22/2025 is hereby made absolute, subject to the condition that the petitioner shall appear before the IO within a period of 7 days? 7 days, 10 days?
Can it be 10 days?
10 days, 10 days, and make himself available for examination, comma, even if he had appeared earlier. He shall not hamper or tamper with evidence. He shall cooperate with the remaining investigation. Stop. Violation of the bail conditions will make the bail liable to be cancelled. The bail petition stands allowed and disposed of on the aforesaid terms. Nowadays, actually, after the directions, this AB has to be disposed of, cannot remain pending for so long. Regular bail, I think 4 weeks, and AB 6 weeks at the most. The time limit, I may be wrong, but something of that sort.
52 time limit.
Hmm?
52 time limit.
Unto.
52. I don't know, 52 timing.
But I've been told my learned friend who's appearing on the, he is preoccupied now. And he'll only be free in the second half, but I'm not feeling well. So may not take up the matter tomorrow, my lord, if possible.
You are not.
No, my lord, he's on links in another court.
Oh,
my lord.
who will be
So, my
appearing?
lord, my lord, Mr. My lord, Jay Suti, our senior colleague.
Oh,
Yes, yes, yes.
you know, Acha, no,
He
you're
was
not
appearing
feeling well,
on
it's
that.
okay, you take care.
tomorrow if possible.
Tomorrow, actually, I'm, because of some constraints, I'm giving a short list, but okay, we'll keep it.
My lord is
Day
not
after
be-
tomorrow, I'll not be available.
But in that case, my lord, on 7th, my lord.
If it's not late for you.
No, no, no issues, my lord. 7th. my lord.
7th is Sunday,
No,
8th.
Oh, sorry, my lord, this is 25th, my lord. 20th,
Tomorrow, we
5th,
can,
my lord.
we can take a chance, subject to, we can take a chance.
Well.
Suppose it does not work out, we'll adjourn it.
My
We
lord.
can take a chance. You know, subject to your also feeling okay. Take care. Kal it out. If it doesn't work out, we'll fix it on 8th.
My lord. Deeply obliged, my lord.
5th also, I'll be available.
Twenty-seven,
এটা সেইটো থাকে 23 or no 33. Oh,
Lordship, on the last occasion, Lordship, a reminder was issued for the FSL.
FSL.
Yes, Lord.
Not yet received, my lord.
what was the matter? This one. One AB is disposed of, right?
Yes, sir.
Disposed of. Do I need to see that order? No, not necessary, right? Oh, this liquor, no? That kancha. I see. They had a fight and that's the allegation. That the otherwise diary was.
Case diary is also not available to them.
Let's see. The other bail AB must have been with regard to co-accused.
Yes, sir.
Co-accused was. The FSL report as called for, it's not yet received. Full stop. Diary you had sent back, I think. Procured the prosecution may procure the up-to-date case diary as well as the FSL report. You wanted to file an additional affidavit to which you file? You
No,
won't
no.
file. The learned counsel submits that at this stage perhaps she would not, though she was allowed earlier, she probably the petitioner side may not file the additional affidavit. So list the matter.
14, 12.
Okay.
28,
Lordship, may kindly, 28 may kindly taken up after some time, my lord.
twenty-nine,
29 CD not received, my lord.
Interim order is there, no?
Interim is there, 1965 AB.
29, my lord, search sheet submitted.
Can it be disposed of then or should we?
That's it submitted.
Search
They are on interim lodge.
interim or something.
FPR.
This is the nature of the allegations.
Family dispute lordship. Mother loss against FIR against the daughter.
Page 13.
Mother
Mother loss.
disposed. They should not fight, but they should sort it out, the disputes, whatever disputes, civil disputes.
Page 13 is the vernacular, 11 is the.
Yes, yes. Itu enake likhi di, Sarma. This last order 18/8/2025. This order will take first 1, 2, 3. Para 3 the same. 1, 2, 3 same. Next, the petitioners were granted interim pre-arrest bail on 18/8/2025. Good stop. It is submitted by the petitioner counsel that pursuant thereof, comma, they appeared before the IO and their statements have been recorded. The prosecution submits that in the meantime, upon completion of investigation, the case has been charged sheet. In the given facts and circumstances, the interim bail granted by order dated 18/8/25 is hereby made absolute, subject to the conditions that the petitioners shall be available for the trial, comma, if one commences. Number 2, they shall not hamper or tamper with evidence. Violation of the bail conditions might entail cancellation of the bail. That's right, standard in everything, all the orders. Violation of the bail conditions might entail cancellation of the bail. Bail petition stands allowed and disposed of.
30,
Password for the bail number. My senior is for personal request. He was not able to.
Personal
I have
difficulty.
obtained permission from the informant.
Yeah, for the informant?
Yes.
Okay. Okay. Diary is just
The diary received my.
diary has been received. Let's fix it. Where will you be? Will he be available day after tomorrow? Day after tomorrow? On 3rd, interim is also there.
Yeah.
Interim is there.
Seven.
5th or 7th?
7.
5th or 7th is also.
Seven.
So, no, not 7th. 8th.
Eight.
7th is Sunday. Your good name, please? Learned Counsel. Learned Counsel and P. Bhattakur, additional PP, and as Learned Counsel for the informant. Full stop. The Learned Counsel for the petitioner seeks an accommodation today as the engaged counsel, and the leading counsel is stated to have some personal difficulties. The diary will be, you will retain the diary?
Yes.
The case diary, with last date also it was there. Is that the case diary has been received and shall be retained till the next day. Full stop. List the matter on 8/12/2025. Next day you do it and finish it. Diary has been there for some time, I think.
31,
Interim bail stands, interim bail granted earlier stands extended till the next date of listing. AB, next one.
Lordship, item 31, Lordship, petitioners are on interim, they have appeared, Lordship. And recorded the matter pertains to some monetary dispute, Lordship.
So,
In this case, search sheet submitted, 31.
supposed. It would have been logo 29. It's not my order, but it's like para 29/8/2025 or para 1, 2, 3 will be same. Just take it. The petitioners were granted interim pre-arrest bail by order dated 29/8/2025. Good stuff. What do we say about the petitioner counsel submits that pursuant thereof, the petitioners have appeared before the IO and the statements recorded. The prosecution submits that in the meantime, upon completion of investigation, charge sheet has been submitted in the case. In the given facts and circumstances, and also keeping in mind the completion of investigation, the interim bail granted on 29/8 hereby made absent, subject to the condition, same condition, available for trial on hamper or temporary, allowed and disposed of. Right?
32,
Report was called for. Yes, report was called. There is no case, my lord, pending registered against the present petitioner, my lord, as per my report.
Then it's not necessary.
Yes.
Just if something happens, then you come again, if necessary. A report was called for from the concerned police station, Barpeta Police Station, regarding registration of any FIR/case against the petitioner. Pursuant thereof, the learned additional PP, Mr. Bhattakur, upon instructions submits that it has been informed that no FIR or cases pending against the petitioner in the said police station. In view of the said information, there is no basis for the apprehension of arrest, and therefore the instant pre-arrest bail petition stands disposed of as not maintainable.
Thirty-three,
33 and 23, my lord, 23 is also my lord, same,
Hmm?
same PS case.
Some in the course of the day.
35,
35 may continue pass over because I have done for the CD money.
Is it?
He is in some other progress. Hello, no, 35.
35.
35, please.
You have gone through the said.
City comfort, city is fine.
FIR is page number 8, your lordship. Relevant portion is page number 11, your lordship. It's the accident case, your lordship. Page number 11, your lordship.
Yes. So homicide section has been given. Right?
106 is there.
In a given case, accident can also amount to
Minor.
homicide. It
Arrest
can
and
even amount to 302
Minor.
also, but that will require different kind of materials.
Minor.
And homicide also, very, kind of, this kind of homicidal negligence. that
Minor,
term,
minor.
homicidal negligence.
Negligence, minor.
Which goes beyond, that category.
Minor.
Alista Pereira is still the leading case happening. Alista Pereira.
The victim was coming from motorcycle, your lordship, and he knocked my let's say, lordship, and after losing the control, your lordship. I have no any willful negligence, your lordship.
What is there's some other decisions also now
Minor.
that say a situation where the matter goes beyond negligence and goes beyond negligence and then reaches a level where the person can be attributed with knowledge also. For example, at 10 a.m. in the morning, if someone drives in front of this road at 100 speeds, then very likely that he will kill someone. So that kind of knowledge can be, that kind of example you can give in front of Cotton College, say. Otherwise, it is always negligent cases.
It is minor. It is from the EM report, it reveals minor cause of this minor. It was
He's been arrested in,
some injuries for minor.
see, because when these accidents take place, people have a lot of grievances, and then, but then some cases of accident may be homicidal, but all cannot be. If as a matter of course it is given, then the process will get, the law was amended, but we, at least, it was only the sentence was increased, but it remained bailable. I'm not saying that it should have been made non-bailable, it remained bailable.
Minor,
So-
here witnesses also said that minor, that Tata S passenger vehicle collect the biker and fled away from the vehicle. Witnesses said in this
He
letter.
was arrested on which day?
Not
Not
arrested,
arrested.
minor, it's a
Oh, sorry, it's an AB.
AB.
Can I have a look at it?
Minor.
Actually, the driver of the motorcycle LLC lost the control and knocked down my vehicle.
Not that case.
There
This
is
their
a
case,
speed
minor.
breaker, your lordship. on
Is
the-
there reveals that?
Minor. It was the passenger vehicle, minor.
Listen,
Police. Minor.
no, roads might have their own share of faults, but
Minor.
it is also everyone's duty to drive cautiously.
Minor.
Driving is a social responsibility also, as we all know. 482 bail application for and B. Sharma additional PP. 482 bail application seeking pre-arrest bail in connection with Margarita PS case number 116 of 25. In connection under section so and so. The an FIR was lodged on where is the FIR?
Is number 11 is.
Yeah, translated to you. We given translated copy.
That's it.
11 on 27/9/2025 by one D Gogoi with the allegation that while his cousin brother Chandra Gogoi, within bracket deceased, was proceeding on his motorcycle AS23AK 8557 on NH 37, wearing helmet, another vehicle bearing registration number AS23AC 2302, driven in high speed, rashly and negligently, hit him on the front side, resulting in fatal injuries, and he was brought dead to the hospital. The vehicle fled away from the place of occurrence. Full stop. The deceased was stated to have been serving as a security in Coal India Limited office, Margaret. The case diary has been received. There is relevant portions. Investigation is going on.
Custodial interrogation may not be necessary, Your Lordship.
The
There is no criminal intention, Your Lordship.
it is noticed, it is stated to have been revealed by the investigation that the time of the accident, the spending vehicle was driven in high speed and negligent manner. And later, the documents of the vehicle were also suspected to be fake, as the record was not found. Good stuff. Investigation appears to be going on to ascertain as to whether the gross negligence, if any, of the petitioner driving the offending vehicle also fell into the domain of gross negligence of a degree where he could be attributed with the knowledge of causing death by the nature of his driving. Considering that the present petition is one for pre-arrest bail, the same stance rejected at this stage. Return back the case there. Let it be. See later on.
Obligation.
Just 5 minutes. না, bill cancellation or upgrade করবে, নিজে appear করবে, petitioner post. এটা আমি বললাম মাজা, he's there, he will take his matter, just a minute. No, first you timing something for you.
Timing item 22. 23, 33,
That's a miscommunication, maybe.
53,
Second half.
28. 28.
28. Let's do 20, others we can do second half maybe. It will be 42. Hold on.
Wait, please, Lordship. Lordship, I am on interim protection, Lordship. And
Yes.
pursuant to the interim order, I appeared before the IO and got my statement recorded, Lordship. Now, Lordship, may kindly find the FIR at case 9. Case 9 is the FIR. The FIR was lodged by the brother of the deceased, Lordship. And there is no such direct evidence that the deceased was ever harassed by the petitioner, Lordship. And in this regard, there is also no complaint anywhere filed by the either by the victim or by the informant, Lordship. That at any point.
How are they related to the, her matrimonial relations?
Yes, Lordship, yes, Lordship. The
Tajibul,
accused Tajibul is the cousin brother of the husband of the deceased, Lordship. And the petition, accused number 2 and 4, they were enlarged on bail by this honorable court. Lordship may kindly see that order at page 14. Page 14.
absolute,
Absolute, Lordship.
okay.
This, and accused number 2 was arrested and now is released, Lordship. So, Lordship, 2 persons are enlarged on pre-arrest bail by this honorable court. One was arrested and the petitioner is the accused number 1, against whom no specific allegation is there. There is no any allegation that at any point in time she was subjected to any harassment by the petitioner, Lordship. Actual fact, Lordship, I have stated paragraph 4. The husband of the deceased stay outside for
Yes.
earning, Lordship,
Hmm.
and the
Para 4,
para 4, Lordship.
I'll
Para
read it.
4 may kindly be seen.
I'll see.
Lordship.
According to you, this is the story. According to you, this is
Yes,
the
yes.
story.
The actual story, Lordship.
Just a minute, I'll come to you. Means out of the FIR 4 FIR named persons,
Yes,
except one, all are on bail
Lordship, all around bail.
anyway.
Petitioner is also, the present petitioner is also in interim marriage.
Okay.
Yes, and husband is not an accused in the.
Yeah,
his
he
husband.
stays up. diary has come.
Case diary received, PM report also received, but PM report regarding cause of death is not conclusive,
Hmm.
my lord. In my opinion, the cause of death is pending till the arrival of toxicological reports from viscera from forensic laboratory.
More than toxicology report,
Yes.
that ante-mortem or post-mortem hanging has to be.
And here there are two, one of the vital witness and statements of Tajibul, the present petitioner. Yes. PM opinion and next, my lord.
Which statement?
One witness and thereafter Tajibul is a present petitioner's statement.
You want me to see Rafiq Ali's statement?
Yes, one of the witness and my lord, next Tajibul Islam's witness. Statement is also there. Other witnesses also there, my lord. Some relation between the petitioner and Tajibul is the present petitioner. Tajibul is the-
It's okay.
Interim lordship, I am cooperating in investigation.
His statement has been recorded. You don't want to call it page 15. Order dated 3/6/2025. And the bottom. It's bishop. Para 2 same para no, just one person. Petition has one file. 3, 4, 5. Make it one para. Allegations. The present petitioner was granted interim prior's bail by the order dated 7/8/2025. Pursuant to which he is stated to have appeared before the IO and statement recorded. Good stuff. It is submitted by the learned petitioner counsel that out of the 4 accused named in the FIR, all the others have been granted bail. Good stuff. The case diary has been received. Peruse the flag portions, the flag portions indicated by the prosecution. The petitioner side, counsel has also drawn my attention to the narration in page 4 of the bail petition, indicating an alternative possibility regarding the allegations and stuff. The statements lend some support to that alternative possibility. With regard to the relationship, with regard to an illicit relationship. I do not like it. Alternative possibility. Investigation is also appears to have reasonably progressed in the given situation. Keeping various aspects in mind, I do not deem it necessary to cancel the interim bail granted earlier. And accordingly, the same is hereby made absent, subject to the condition that he shall cooperate, he shall be available for trial if one commences, he shall not hamper or tamper with it. The standard violation of bail conditions might entail cancellation of the bail. Return back diary, bail petition stands as posted.
Deeply obliged. Admission item number 10.
Bail over. The bail है तो video पर admission also किसी अपनी video पर applicable ना है, that is come solution. Wait, है तो emergency bail cancellation of अपनी law पर. Hello, attend for out.
Maybe. Yeah, in this case, my lord, this is the case concurrent finding, my lord. I am for the respondent, my lord.
Right.
Initially, I was a complainant in the NI case, my lord.
Right, right.
Both the court have decided
Against him.
against him. On the basis of section 139, my lord, the holder of the check.
Yes, yes. Have you got any money till now in terms of by 20% or whatever?
No,
Nothing.
no, my lord, that is my humble prayer, your lordship.
At least that such a power has been explicitly given to the. You just correct me, I may be wrong also. It has been explicitly given to appellate court at the time of appeal, but I don't think I have not noticed it with regard to revisional court. Is it? Is it given? I don't know. Probably, I think it's not been given, only to appellate court. But it can, this question can come up at the stage of revision also.
My lord,
That
revision
whether
can
it should be
also-
stayed subject to, but
Payment, my lord.
otherwise it has to be heard. It has to be. Should we admit it and post it for hearing? But it will, what is the matter? 24 matter, right? But it will come chronologically like that. Heard, none appears on behalf of the petitioner side at the moment, full stop, on call. Full stop. Your good name, please?
R.A. Chaudhary.
R.A.
R.A. Chaudhary.
R.A. Chaudhary, Learned Counsel, appears on behalf of the complainant / respond number 2. Full stop. No, no, like it is respond. Sole respondent / complaint. Full stop. Who submits that the petitioner is filed this against concurrent findings of guilt against him arising out of CR case number 35 of 2018 under 138 of the NI Act 1881. Full stop. The check amount was stated to have been 3 lakhs. And it was the appellate judgment remained same, absolutely.
Same on, earlier it was 5 months, my lord, imprisonment, that was reduced to 2 months.
2 months.
That is the difference. The amount is same.
The amount is same. What do you suggest? I can admit it, but subject to that risk that will come in this thing. But everything cannot be disposed of at the stage of admission also. Especially these are not second appeals, but these necessitate some time. Actually. So in any case, they are not there. Other option is either we admit it and post it on a hearing day, or keep it at admission stage in a hearing day. That these are the only 2 options.
Okay, lordship may give it at the admission stage, my lord, instead of admitting the thing. Let them. We can decide. The whole problem
How-
is, my lord, this is the complainant, my lord, he is suffering from.
Yes, they have this. That is why this law has been
For it,
made stricter.
For his medical expenses, my lord. he is
This made has
unable to-
been made stricter,
is-
and still, still it is having so much problems. Anyway, we'll have to examine his guilt within the ambit of revisional jurisdiction. How about January? 1st week of January.
First we could-
This is the matter. Let it be on 8/1, 2026. In the admission column?
Admission column. Deeply applied.
এটুকু মাফি যাক। এটুকু মাফি যাক। এটুকু কোনটা আছেন? 65 না এটুকু
Into 10.
9 তো একজন করেছেন। একজন করেছে। 10 8/1 2026. Upgraded.
I think 89%. Yes.
What was your matter, sir? Your
Twenty.
which you wanted me to hear, upgraded?
This is 57.
Look, actually, 4 matters have been tagged together.
Mm.
IS 799 and IS 665 are for cancellation of bail.
I see. Oh, this is the ones then. 56, 57, 58. Okay.
there is a criminal petition which is for quashing of FIR by the accused,
Mhm,
and there is an IA 195 of 25,
mhm.
which is on the register and SPW.
Okay, the bail cancellation is, one is 195.
One, bail cancellations are 799 of 23
Okay.
and 665 of 24.
665, right?
Right.
Okay, then.
Fifty-six, 57.
And criminal petition 558 is for quashing.
For quashing by the accused.
One of the accused.
Yeah.
There's only one accused. Tagum
Lordship,
Neri.
799, the accused is the petitioner of the criminal petition.
Mhm.
And in 665, there is another accused.
Mhm. We can just look into it.
Lordship,
No,
just allow me.
touch the matter, then see what is there. Since you have requested. Otherwise, black us, no, addition, criminal appeal black us. Wait a minute. Hmm. You don't know. Mhm. Who would be representing the prosecution in this case? Whatever.
One on behalf of respondent number 2, one Sarfraz Nawaz appeared earlier.
No, that was a different case also.
Oh, different.
That was a different.
But could you inform them?
I informed them. Lordship.
Inform.
Yeah.
Because since we are upgrading, we're trying to upgrade because.
Lordship, the actual problem that has arisen is that with the tagging of 4 matters altogether,
Mhm.
because of one reason or the other, it's getting delayed.
Mhm.
799 is the 27th time of listing today, Lordship. And each time when I appear to BC, the Lordship asks me to appear in person. And when I come in person, it's at the bottom of the list.
I understand your difficulty.
And now, Lordship, the reason behind these petitions are,
There's a direction for tagging, that's why it has been tagged, right?
Lordship,
The 2925, it is that in order that the matters be listed along with criminal petition 558 of 25.
No.
They are required to be tagged, continue to be tagged.
no,
or
not
we
required.
can let go, so.
Lordship,
So anyway, let us just enter into it just a little bit. Let us enter into it a little bit. First, we see the bail cancellation matter. Yes. Since it's not reaching, so I must address your grievance. My duty to address your grievance. Then we'll see what happens. এইখিনি গোটেই হেৰি কৰা আছে গোটেই নালাগে এইটো বাছ ইমান নালাগে ঠিক আছে ইমান নালাগে okay IA criminal 799 is the bail cancellation.
as well as 665, Lordship.
Okay, it's double line. 779 of 2023. You're right. I'm just looking into the matter. Let's see. Is it about? The IA is also quite old,
Not-
23. IA is also to its.
Lordship,
Anyway,
Be-
so
best
what,
of the
what
effort-
is the other one? IA
IA 665 of 24.
6.
Yes,
665.
And Lordship, the third IA 195 is tagged with 665.
That also pertains to?
That is out of this 665, Lordship.
Yes, out of this. I get it. Just a minute. Write it down. You're from law background? No, but you can address me or this court in any comfortable mode you feel like. So that's okay, no problem.
Lordship, before going into these petitions,
Yeah.
a little background will be required to be known for a brief understanding of this case. An agreement was entered between my mother, who is the owner of the excavators.
Mhm.
Excavators are JCB-like machines, sir.
Mhm.
They are chain mounted, JCBs are tire mounted.
Mhm.
She let it out on rent to a person in Arunachal Pradesh.
Mhm.
The agreement was entered in Dibrugarh, Assam. The person took the excavators, but he did not pay any money to my mother.
Mhm.
Up to this point, Lordship, it is a civil issue.
Right.
But in utter criminal breach of trust, he misappropriated and sold off the excavators belonging to my mother.
I see.
Since the agreement was entered in Dibrugarh, Assam, a complaint was lodged and the FIR was registered.
Hmm.
The police at first closed the case as civil nature.
Mhm.
Upon a protest petition being filed, the case was asked to be further investigated by the learned magistrate,
Mhm.
Dibrugarh. Now, Lordship, the prime accused runs to this court with an anticipatory bail petition 2355 of 2019.
Mhm.
Though I am not a party to this petition,
Mhm.
because in general, we are not made parties, the informant. But as
of now.
of now,
That's
only
emerging.
POSCO or some other
Yeah,
cases
that's
it is.
emerging now. As of now,
Now,
usually.
since it was a somehow it entered my ears that he has rushed to this court, we can check up with the case status and CIS systems.
Hmm.
We get to know that there is an anticipatory bail pending filed by him.
Hmm.
We obtain a certified copy of the petition,
Hmm.
as well as we enter appearance here
Okay. During
Yeah.
its pendency.
as an informant.
Mhm.
Now, Lordship, in the petition, I find that he has attached a forged agreement.
Right.
Now, the copy of the forged agreement is found attached with the petition. Generally, in criminal cases, we don't attach the original copies. We attach certified copies.
Usually.
Now, when I get to know that he has attached a certified true copy of a forged agreement, I register one complaint with Latasil police station because Latasil has a jurisdiction over this court. A case is registered. I file an affidavit in opposition with this court
Mhm.
in this petition
In the AB.
in the AB,
Mhm.
highlighting my objection to the bail, citing forgery.
Right.
Now that affidavit is overlooked and he is granted absolute bail on the strength of the said forged agreement. Now, this Latasil FIR was registered in the year 2019. And in 2023, he is charge sheeted for forgery in court.
I see.
Learned trial court takes cognizance. The accused is summoned, but he never appears before the trial court.
Hmm.
Now, Lordship, he comes up with a quashing petition before this court.
Hmm.
The trial court records were never received, which is criminal petition 558 before your lord.
Hmm.
He is granted a stay.
Hmm.
Without trial court records, the matter is heard and reserved for verdict by Honorable Justice Pathak. The verdict never came up.
No, just we should let us not.
No, I am
take
telling the
any
entire
ins-
facts. Now, why this criminal petition has come, I mean, touching on that, Lordship. So, since the verdict did not come, I pray for further hearing and it is before Lords for the further hearing.
This, the stage of the case is in order, Lordship.
Can I have a look at the bail order in AB 2355 because for me it's new, right?
Lordship.
It has a checkered history, obviously.
Lordship, it's continuing and Lordship will be quite surprised to know the Dibrugarh case is pending since 18 till date.
The PS case.
Yes.
In the trial court.
Investigation stage in the police station. I have an IPS officer rank as my investigation officer. And the accused has stated on oath that he has paid the police 80,000. I have that certified copy of the record also. He has filed in Itanagar bench. Dibrugarh police 80,000.
Anyway, we just started looking into it.
Lordship,
right?
I will take my lords to the
I'll-
order.
I'll look into it, everything.
Page 99, Lordship.
Page 99. Oh. I found it just to know that.
Should I read the relevant portion of it?
I can also go through. I'll spare you the trouble. I'll just go through it myself. PS case was Dibrugarh 442. right?
Lordship.
Which
2018
is,
Lordship.
which is stated to be still pending, as you said, no?
Lordship.
In the form of the further investigation.
Lordship.
Anyway, so what was this thing? One aspect I just want to. Excavator was taken on rent, 3,550,000 per month. It was not paid. Then the allegation was that it was sold off.
Lordship, he did not pay us up to that, we were fine.
And then it was sold off.
He sold everything off.
And then according to you, that is criminal breach of trust.
Lordship. He has taken it for a period of 4 months. So you pay me, you don't pay me, that is a matter of civil court. But you have to return it back to me.
So in the third, now you come to the, you have the order before you. In the second page, the third para, the petitioner submitted that he had an agreement with the informant. This is the agreement which was forged.
Forged agreement is being referred. The forged agreement forms the basis of the bail order.
Because the learned judge referred to that.
No.
That is according to you, fraud,
Not
forged.
Forged. And the affidavit was also before this order.
Anyway, so.
The affidavit can be had, Lordship, at page 131. We filed this affidavit during the pendency of the petition.
Right.
Page 133, para 4, Lordship. That I say that annexure 3, which the applicant has stated to be a piece of agreement purportedly executed between the applicant and myself, is a forged agreement. And as soon as I came to know about the same, I have lodged an FIR with against the same before Latasil PS on 17/10/19, and investigation regarding the same is going on. We got it through the notice of the
And it was registered as Latasil PS case number?
326 of 19. Lordship.
So,
Nothing. Time never. How much is it? 2019. and that this case has been charge sheeted, but trial is not progressed.
Hostage taken.
But it's going.
He was summoned, he did not appear,
Uh.
then he got a stay here. The stay was till 27/9/2024.
I see.
Thereafter, the matter came up for fresh hearing.
Uh-huh.
It came before Honorable Justice Manish Chaudhary, who did not grant a stay.
No, we can't
And
take
no
any
stay,
names.
but still the trial court is not proceeding.
It's pending hearing, that means.
They say that the order precisely indicating the word vacated is not there, so we will not proceed.
Nice. Yeah, maybe. Anyway, now you proceed next.
Now, Lordship, this case charge sheeted, cognizance taken. Now I have come before my lord for cancellation of bail under section 439, subsection 2 of the Criminal Procedure Code.
Okay.
Now, Lordship, the matter was heard at different points of time. The accused filed an affidavit in opposition to my prayers, highlighting two basic facts. That he cited one ruling of Abdul Basit, saying that this court cannot revisit its order under 362 CRPC, and that I am barred from filing a case against him for forgery under 195 1B2 of the CRPC. Now, basically, Lordship, our arguments are based on these two aspects.
The documents which are submitted in the court,
If the court, if they are forged, only the court can file a case.
340, something of that sort.
340 CRPC with 195 IPC, that is the general case. And he says that since the forgery was in this honorable court, only the court can direct.
Okay.
Now, these 2 points were raised in his affidavit of opposition.
In the bail cancellation procedure.
Lordship, 799, there is an affidavit by the accused. Now,
No,
Lordship,
that has a bearing on the efficacy, not on the maintainability of that prosecution. But the cancellation of the bail would be on a different footing.
Lordship.
Whether that criminal, whether the Latasil case can proceed, whether that will be maintainable, that would be determined by whether you can proceed or the court can proceed. But as far as cancellation of bail is concerned, we have to see whether the court was misled. Right? Next.
Lordship, there is a judgment of the Apex Court in SP Shengalvargaya Naidu versus Jagannath, 1994, 1 SCC 1. And if we come down to 2024 Bilkis Yaqub Rasool, the court has said that when you obtain a degree or judgment by fraud, it becomes a nullity. You lose your right of audience, you cannot be heard, you should be thrown, not just thrown, kicked out of the proceedings.
Fraud vitiates everything.
Lordship. Fraud and justice don't dwell together. When the forgery has been established, you have been taken cognizance. Now what remains in this bill? Nothing. With regard to 195 1B2 Lordship, it is with respect to forgery done in proceedings. If the forgery was done in the court would have done the case or the complaint. But when you do a forgery before coming to this court, you manufactured a document quite prior to coming to this court. You have only attached a copy here. So this court is not barred under 195 1B2.
That is actually that is where these disputes lie.
Lordship, Meenakshi Maro, Iqbal Singh Maro.
The concept of custodial legis, that whether the when the document comes into the court becomes the custodian, and thereafter forgery before that, and forgery while the document is custodial legis. The law is centered on these aspects.
Absolutely.
Whatever little I know.
The word is custodial legis, if I am pronouncing it right.
Legis.
And the settled judgment is
term.
Iqbal Singh Marwa versus Meenakshi Marwa. If somebody does forgery in this court, suppose I am appearing now and I make a forgery here or submit a document which is forged now here, in original the court will do. But when you do forgery prior to coming to this court and you have attached a copy is not a document. The court is not barred. The complainant is not barred at all. Iqbal Singh Marwa is very, very clear on this.
Okay, I'll see this. Iqbal Singh Marwa. Okay. Thank you for giving.
Now, Lordship, coming to this 362, that once this court has granted a bail, the court cannot revisit
No,
the order.
that is,
That is
that is on a
something which
different.
he's
No,
trying to make
we-
this
We
court.
all agree that criminal court cannot review a final order or judgment.
Lordship, it's an
But
interlocutory order.
cancellation of bail is, it is a specific power
Lordship,
which is not reviewed.
to my very simple knowledge of law, a bail order is an interlocutory order. It's not an intermediate order.
Hmm.
And 439(2) specifically gives you the power to revisit.
Yeah, that is, that is clear. That
Now
cancellation of bail power, it does not amount to exercising the power of review by criminal court, which is but except for final, except for typographical errors.
Now, Lordship, I have come with a lot of judgments from the Honorable Supreme Court, which says even if you have not violated the bail conditions, the bail can be cancelled. When you play fraud on this court, you lose your right of audience. You cannot be heard at all.
Yes.
Now, Lordship, there is fine point I would like to address this court. The issue is very simple. I say the agreement is with my mother, between the accused and my mother. The accused comes here and saying that it is between the accused and me. So if I put it in simple ways, I say I am an Indian. He says you are not an Indian. So if I can prove my citizenship, his wording goes. He filed one case against me in Arunachal Pradesh. I submitted the documents of the agreement between my mother and him. And the forensic has found it to be true. No point of time we said there were two agreements, neither he nor me. So if my point is proved, his point goes. One fine point more, Lordship. The Latasil police has never been able to seize his documents, which he produced before this honorable court. And for that, ACP Panbajar was under FIR by the SDGM to Kamrup Metro. He has filed the criminal petition. If my lords come to the affidavit section, I will take my lords to it. It's a case, Lordship. He has been playing around with this court.
So,
My lords, can please come to the affidavit portion.
just a minute.
Yes.
Not be frozen. Not be frozen. Take this. Not got part what was any session. Okay. Not before, sir. Affidavit section. Yeah?
Lord.
Affidavit section. What is that? Affidavit section. No? Affidavits.
Lordship can kindly.
You can, madam, you can sit down. It'll take some time.
My lord can kindly look at this petition. This is by the accused in Itanagar bench. Here in the affidavit, he
Just a
says,
minute. Let me record, just locate it and mark it from here. So that for future reference. The affidavit filed by the
accused
in the
Itanagar bench. He
in the
says-
criminal petition.
Yeah. That the annexures annexed to the connected petition are true and correct copies of the respective original.
Which criminal petition is it?
It's a petition filed in Itanagar bench, Lordship, not
Okay.
here.
Yeah, Itanagar bench. Yeah.
And I am carrying the original certified.
That is disposed of.
Yeah, Lord.
That is disposed of.
Now, Lordship, when somebody says, I am attaching a true and certified copy, it means that he had the original in front of him.
Yes, yes, definitely.
It is only then that the certified copy can be made.
Yes.
So up to 24, he is attaching certified copies. That means up to this day, he is having it in his possession. And he has never submitted it for forensic. He is playing with this code.
Right.
A person's liberty is supreme, but he cannot be allowed to roam about playing fraud on this code. He has been charge sheeted in a number of cases of shit, and never he appears anywhere. And the accused in 799 is a more horrible one of shit. He is under warrants, but he is also not appearing. What a misery, Lordship.
The affidavits. Affidavits. Anyway, we'll locate it later. Now, which document should I say next?
Lordship, I wanted to produce this one.
You just give me. Have a look, then we can tally it. Yes, sir. Hmm? Arunachal. What should I see? The affidavit.
Lordship, he said each and every attached document is a true and certified copy. Now he has attached that false document also here. The same that was attached in this course. Lordship may also see annexure 68A of this petition, Lordship.
Annexer 68
68A, Lordship.
of this one, this bunch.
This is not before my Lordship, so I'm just trying.
Annexer
68A, Lordship.
68A is not here. Annexer 11. Page number or annexer? Page number.
Maybe Lordship 68A. Page, maybe Lord.
It will be page number. Yes. Typed copy.
Lordship can see Dibrugarh Police 80,000.
Annexer 9.
No, not so.
Hmm. His bill.
He has given.
Someone has made a bill.
No, he has submitted to the court that in this excavator expenses, I have paid police 80,000. And that is the reason the Dibrugarh case remains pending since 2018, Lordship. With an IPS as my IO.
Anyway, this right disposed of. So what was the prayer in this?
My lord, I have come prepared with some.
I'll just a minute. I'll come to you. Just seeing the. What was the outcome of this petition in AP?
Lordship,
in
he
Itanagar?
has filed one case against me. It was submitted as FR. He went for further investigation without an affidavit. And the case is again been closed against me.
Lot of protracted litigation. Anyway, so
Now, Lordship, the litigations are being filed one after another to delay the main case.
okay, to
May I place some judgments of the apex court, Lordship?
just a minute. And then do I need to have a look at the criminal petition 555 also? Because they are the petitioner. You're not appearing in this, right?
I am the respondent number 2, Lordship.
In this
Yeah.
558. I just see the this last order.
Detach this 558 and have it tomorrow.
Tomorrow I have some.
Or
difficulty,
maybe
but
on
we'll
Wednesday,
hear-
Lordship.
we keep on hearing. If necessary, we'll keep on hearing
Lordship.
till we finish. What was the interim order passed in this criminal petition, criminal petition, this criminal
Lordship,
petition,
there was a stay
criminal
grant.
petition 558 of 2024.
Lordship, after it has been
I'm trying to locate the original stay order,
26, 2024, Lordship,
26, 2024,
passed by Honorable Justice P.J. Saikia.
26. After hearing of the, no, that's okay, still state. For caution, this was. You are the petitioner in this case, right?
Lordship, in item number 56, I have put a respondent, private respondent number 2, and in 57, the petitioner.
57 is this criminal petition,
Yes.
petitioner, right?
Now, Lordship, this
Just. They filed this petition for quashing the Lata Sil case.
That is.
Okay. On the FIR lodged by you dated 10/10/2019, right? And the original proceeding, from where AB 2355 had emanated, that is in Dibrugarh. So any quashing proceeding against that, they preferred, that no quashing proceeding has been, but that is at the stage of investigation. And no quashing proceeding has been preferred against that. And you are seeking, he's on bail and you are seeking cancellation of that bail. Anyway. Yes.
Lordship, actually, I'm appearing on behalf of R. Sonar Lordship.
Yes,
He is the
I
English
understand.
advocate Lordship.
Yes.
Actually, today the case has been fixed for order only.
Mm.
So on the last date, the court has asked for the lower court record of PRC 878.
Yeah, I noticed, there's an order also to furnish an explanation, not an explanation, it's mentioned as report. But
Yes,
despite repeated reminders, the case record has not come.
Lordship, on 26/11,
26/11/25.
In the criminal petition?
Lordship.
In the criminal petition?
Lordship.
Yes.
As per office order, note order dated 26/11/25.
Office note?
Lordship.
Just a minute, I'll come. 26?
11/25, Your Honor.
26/11/25. That's a recent,
File hasn't received, Lordship.
No, they have sent it by email.
has been received.
File A, I think. File A.
26/11.
Received through email, Lordship.
Thus, it was, I don't know.
File it out.
I'm not getting it.
Okay.
No, office note to be served. 26/11/2025. 26/11/2025, office note.
Lordship, even in this criminal petition,
Mhm.
we don't need to go to the trial court record because it has also been filed suppressing facts. It is not
Anyway.
maintainable at all.
Anyway.
May I take my lords to just 2 paragraphs of the
No,
petition?
at the moment, I would not prefer because to go into the criminal petition straight away. But the bail cancellation matter, I
No.
think we should focus. It needs to be tagged. No, I will not detag because there's an order, it might,
Lordship,
because,
what happens,
I have
suppose
not gone sufficient detail into the matter, I have gone into, I have just touched the surface.
The file even, Lordship. Lordship, may kindly fix the date, Lordship.
You are saying that we should hear it another day.
Lordship, on 28/10, they chose their lucky day to be today. Though it has come under the orders column, but it was their chosen day.
No, I will hear it. It's become part of.
We disposed within 2 months. How can this petition lie for 3 years?
No, cannot be. Actually, I will.
They are into bench hunting and forum shopping.
No,
Lordship.
we'll dispose it off. Don't worry. Dispose it off. A scan copy of case record of PRC 26/11/2. They can have a look, I think. Would you like to have a look? This one? You can have a look. 26. You have pointed out the scan copy of PRC 878 of 2023 from Dibrugarh.
878 is Lordship Lata
Latna Sit.
from Kamrup Metro.
This has been received. That has been received. But Dibrugarh, no,
Lordship, Dibrugarh was received much earlier.
much earlier. So anyway, I'm not deep tagging because I think I have not gone fully, so much into the detail because of the protracted nature of the litigation. Because otherwise, it may, I'm not sure whether it will create any complication if I detect. But let it remain like this. But this IA will keep it as part of this IA. Your bail cancellation, I'm keeping it as part.
799 and criminal petition 558, let it be together.
No, it will be together.
And
but
the
BA will be
other
part
two
of.
can be released.
Which one?
The 665 and 195, because the respondent is different from there.
But 665 is IA 665 is tied up with 558.
Lordship,
The party is different.
I am praying that IS 799 and 665 and IS 799 and criminal petition can be tagged together and kept as part heard.
It is with also.
Lordship. But the other two IS, which are IS
No, no, this is
665 and 195, they can be detached.
No, no, I beg to differ because since it is already tagged together, so let it remain. It will remain like this. It will not cause any harm. But we can proceed with this.
Lordship.
It will come in this form only, but we can proceed with this.
As per law.
Proceed with this.
Now, Lordship, may I place some judgments of this honorable apex court?
Today or another day?
Lordship, let us complete, because I am coming from Calcutta just because of their chosen day.
Okay. So we are hitting lunch time, so we can. How long will you take generally?
Just half an hour.
No, no, I'm not pressing because other matters are also there.
I can address this court at 4 also or 3:30 or 3:02.
But I'm keeping it your bail cancellation matter as part heard. So we can fix short dates and it'll keep coming.
Lordship can kindly hear me today. I will not take much of a time. I'm ready with my argument.
No, some matters do take time, but we can make it in installments to save time. I will start at 2 then.
Sir, kindly fix another date. Actually, the Genghis Senior is.
Lordship, I vehemently oppose it.
This matter, since he has appeared in person, let us hear him, say for another half an hour. From 2:30, I will proceed with the other matters, right? Because see, on all sides, because it should not keep pending for so long. That's that would be our problem, this side problem. So we shouldn't keep it. But since he has come, so we should give an opportunity. You submit for another half an hour, and after that, if something remains, then you can have another day. No issues. No issues. Then I'll hear them. Then you can join on VC. You said your experience as VC has not been good, but still you can choose to join for reply through VC, or you can, if you want, if you have some work in Guwahati, you can come again. I cannot say that you. Just take for some time then. Yes.
Lordship,
Yes.
the issue before us is that I am praying for the cancellation of bail granted under Dibrugarh Police case number 442 of 18 under anticipatory bail petition 2355 of 2019. When bail is the norm and jail is an exception, I come praying before this court that since the petitioner has obtained bail on fraud, forgery and misrepresentation, such order cannot be sustained in the eyes of law. Lordship, before I take my lords to the judgments of this honorable apex court, my lords may kindly come to the anticipatory bail petition AB 2355 of 19 filed by the accused.
It will be in the, I think, is it in the IA also? Annexed in the
Lordship, I will just point out the number.
IA to the doctor. It will.
Page 75, Lordship.
No, not this one. 799. 799. IA 799.
It might be IS 665.
No. We are taking up the first one.
799.
Sorry, man.
Lordship, for a simple explanation,
Yeah, just a minute. Is the one to Okay, it is available in this file.
Lordship, IS 799, page 75, Lordship. Though the records were destroyed, but I had a certified copy of the petition, so the certified copy is attached here,
75.
Lordship.
Yes.
Now, Lordship, for a plain reading, the accused was Tagung Neris. For convenience, we can say him as AB. Now the petition is filed by ABC. If Lords come to page 76. In the matter of Sri Tagung Neri Talo, son of late Neri Talo, the son of a dead man. Now, Lordship, this petition has been affirmed before a oath commissioner. To my understanding of law, Lordship, when we approach the oath commissioner, we are to produce a photo ID which contains the name as in the cost titles, as well as the photograph which matches with the face of the person signing it. Now the affidavit in opposition is filed by a person called Tagung Neri, AB. How can this affidavit could have been sworn? He is the son of a late man in the cost title, and by the time we reach the affidavit, his father jumps up from the grave. He becomes alive.
Neri Talo,
Lordship. And if my lords come to page 87,
son of Sri Chang Neri Talo.
now he was dead in the cost title, he has become alive in the affidavit. And in the affidavit in opposition, he has a third name.
Okay.
The FIR in Dibrugarh was filed under section 406, 420, 323, 294 and 506. But here he has sought anticipatory bail on 406, 420, 294 and 506. He has suppressed 323.
That's a bailable offense.
Lordship, it may be
But it should
bailable,
mentioned.
but it features in the IPC, it's an offense.
It should be mentioned.
Lordship. Now, Lordship, there is a peculiar case before my lords. The petitioner approached this court first. An order was passed by Honorable Justice M.A. Ali, Mir Alfaz Ali on 25/7/19. He was granted an interim bail of 20,000. The order was extended by Honorable Justice H.K. Sharma on 38/19.
No, it's the court speaks, so we will not take the names.
Sorry,
It's not necessary.
I was.
It's not necessary. We
Now,
all
what-
speak
what
to the
is-
court.
Now, what is very interesting is that the interim bail granted on 25/7/19 was extended up to 38/19.
Okay.
And on 23/9, when it came up new, afresh, this court granted another interim bail of 10,000.
Anyway. Okay. And thereafter it was made absolute.
Now, Lordship, that is the case. Which bail has been made absolute? The first one, which died a natural death 2 years ago. The interim bail on 25/7/19 has been made absolute. But that was discontinued on the third day.
It was not extended.
No, the bail of 23/9/19 was extended till date.
That is another aspect.
Lordship.
Anyway, there was a gap in between.
No, Lordship. When it came up for the third time, a new interim bail was granted. The first one was left.
Because there was a gap in between.
No. It was continuous.
It was not extended.
No. It was just abandoned, we can say.
So thereafter new interim.
A new bail,
according to
interim
you.
bail.
According to you.
A second interim bail, we can say.
Okay.
And that continued till the last day of order. But the first one, which was discontinued or abandoned, was made absolute.
Okay. Then
I have placed the first order before Lord on the earlier occasion. If my lords have it, otherwise I will place them again, Lordship.
it should be here, I think.
The first order I have placed and the third order where a new interim was granted, Lordship.
It is that page.
No, Lordship, I handed it over to the court on the last date.
Last day.
They are marked with a pencil as number 1 and number 3, Lordship.
Yes. fine, but, anyway, so proceed, and we'll find that. It's a matter of record, so we'll find out.
Lordship, I am having the next interim bail order, if my lords allow me to place it. It can be compared with the final order.
Okay.
Now, Lordship, the case before us is that the accused took 4 excavators, entered an agreement in Dibrugarh, did not return it, told them off, hence a criminal cognizable offence committed, a case registered. He comes before this court praying for bail. Up to this, it's fine. What he does here, he says the agreement is not with the mother of the petitioner. It's with me, the petitioner. So here we are antipodes. We neither of us say that there are 2 agreements with my mother and me, nor he says. Either it is him or me. Latasil police conducts an investigation, submits a charge sheet, the trial court takes cognizance. He has attached the order of the trial court saying he was never issued anything from the court, but he has attached uncertified copies of the order and charge sheet, suppressing the FSL report, which amounts to another offence under 466 IPC for submitting tampered copy. He has filed an affidavit in opposition to my petition, where my grounds are suppression of fact, makes the petition non-maintainable. His ground is that I have not violated any conditions of bail. Now, Lordship, this is a post-bail conduct. Violation of bail conditions can only be known to the IO when the case is under investigation stage, not to me. Honorable Apex Court has said, even if you have not violated the bail conditions, your bail can be cancelled by the court. I have that order with me. I am before.
Yeah, it can be.
Lordship, before going into that, let us now assume a situation when the maintainability has to be tested first. A petitioner in a bail petition cannot treat this honorable court as a laboratory for experimenting with lies. He comes to this court hiding the facts under the carpet. He places an agreement which he could not produce till date for forensic. Whereas my agreement has been found to be true, I have the certified copies of the FSL. He further submits in his petition that he paid a sum of 14 lakhs to me at my guidance. He couldn't prove a case. He spent 11 lakhs on my excavators. He couldn't say. What he has now done in his affidavit of opposition, he has attached some pro forma invoices. Lordship will be pleased to see the affidavit in opposition and pages 249 onwards. How can somebody be allowed to play such a fraud on this court? Pro forma bill form, no name, nothing. Can this be treated as an expenditure incurred by the petitioner? 249, 250, Lordship. Each of the pages doesn't have a name. You spent 14 lakhs. There must be some GST incurred, some money receipt there. Even the name of the buyer is not there, Lordship. Now, Lordship, when somebody approaches this court with unclean hands, primarily there are 3 things involved. His petition should have been dismissed in line with explanatory costs. The petition should have been dismissed and contempt proceedings should have been initiated against him. Now, since he has got bail, I am on cancellation of bail. My lords can look up at this. Further, in his anticipatory bail petition, he said that I have abandoned all the excavators with the caretaker. There was no caretaker. Now, in his affidavit, he comes up that I am now submitting the excavator to Dibrugarh police. Lordship, to what his post-bail conduct, there is a report by SP Dibrugarh, which I may kindly place before my lords. The post-bail conduct of this accused is still more grave.
In the Dibrugarh case.
Lordship, it was called for by this court on an earlier occasion and I was handed over a copy of that.
It is annexed here.
It must be in some of the files, Lordship. If my lords allow me, I will just place it over here.
Affidavit.
No, it's not in the affidavit, Lordship.
I have to see.
Lordship.
Okay.
It was okay. Because a lot of files are there, Lordship. May I please place it?
A few years, need to be worried, no? God bless you.
Now, Lordship, when somebody is on bail, it is considered as a constructive custody of the court. He is duty bound to cooperate with investigation and come as and when called for either by the court or by the police. Now, Lordship, if I may take my lords to the last para of the first page. The IO could not arrest the prime accused, Tagung Neri, as the accused person was absconding and evading arrest. The IO also revealed in his report that from the material seized from Junai PS, the then OC Junai PS and G. Bora, Sri G. Bora did not follow the proper procedure by seizing and releasing the excavator. That means the excavator that is still in his custody. Further, the IO also stated the OC, Mariang border outpost of Inkyong PS did not provide necessary assistance to nab the culprit Taung Neri. As per documentary evidence, Taung Neri is in unlawful possession of an excavator bearing registration number NL1B299 and has refused to hand over the same for production before the Honorable Court. We submitted in 19 that he handed over everything to the caretaker. In 25, the SP is writing he is still in custody. Now, Lordship, the next para. The third line, issued notice under section 91 CRPC for production of relevant documents and agreement made with the complainant. But he has never appeared. Now, Lordship, the observations, para 1.
Following observations.
Lordship. During the course of investigation of the instant case, the IO stated the following observation. 1. Excavator bearing NLB 197 seized by the IO at Mariang is yet to be produced before the CGM. Dibrugarh case due to missing expensive major parts which are yet to be recovered. Ganesh Sarkar and Pramod Bora were granted anticipatory bail in AB 2046. Now, Lordship, he was the first person to be granted bail. And the next line is very surprising. They did not appear before the IO after obtaining bail from this Honorable Court. Now, when they did not appear, what was the IO doing? It's a big conspiracy, Lordship. Several police officers have been arrested in Arunachal Pradesh. A DSP has been arrested. An SP is going to be arrested.
In this?
Lordship, 7 police stations, 8 courts, including this Honorable Court and its underlying bench at Itanagar. Several of them have faced framing of charges and they are facing trial. But none of the excavator has been recovered till date. And the accused are enjoying bail on forged documents saying that I have no right to file a complaint because the forgery is in court. If the court wishes, it will file. It will. If the court doesn't wish, we are free. Now, Lordship, the last 3 lines of the second page are very, very important. The number plate and identification marks have been removed from the said excavator, making it difficult to establish that the said excavator is NLB 299. Now the police has got something from the accused which is not identifiable. Now, Lordship, the third page. This shows the conduct of the police. Lordship, the point number 3. Excavator bearing registration number NL1B676 is yet to be seized and recovered and yet to be produced before the Honorable CGM. The next para. Excavator bearing 797 was seized. A lot of things. Now, if my lords can come 1, 2, 3, 4, 5. The 6th paragraph. Lordship, in para point number 3 is saying 676 yet to be seized. The IO of the case duly seized 3 number of excavators bearing NLB 299, 676 and 797. A few lines above you say nothing seized. Coming down 5 lines you say seized. What reliance can we have on this report, Lordship? The same 676 yet to be seized, after a few lines seized.
Okay.
Now, Lordship, the last paragraph, last page of this is also fine.
This you take back? Since it must be in the...
During the course of investigation, the IO sent a letter dated 19/7/24 to the OC Doimukh PS District Papumpar, Arunachal Pradesh seeking detailed report in connection with Doimukh PS such and such, which is yet to be received. Further, a reply was received such and such. The IO have also sent a notice under 41A CRPC to Taung Neri, alias Chalo, son of such and such, to appear before the IO, but no reply has been obtained from this end in this regard. Now, this is the post-bail conduct of the accused. After obtaining bail on forgery, fraud documents, he has vanished in thin air. The SP is writing a report that the accused is not submitting, but he is not using his powers vested under CRPC to make him abide by law. This petition should have been filed by the state, not me, Lordship.
Okay.
In the anticipatory bail, Lordship, which we just at page 75, which was started, there is another fine issue which needs to be brought to my Lord's notice. My Lords may kindly come to page 98
98.
of my petition 799, which is anticipatory bail. Now, Lordship, the stand of the accused is that he entered into an agreement with me, not with my mother. Here he has attached a letter addressed by the accused to my mother. So I question him in my anticipatory bail cancellation petition, the IA, that when you have not done something with my mother, like an agreement or anything, how can you come into the possession of this? Because it is addressed to my mother. It should not have been in your possession. Because you are denying any relationship with my mother, either agreeing or anything. In the affidavit, he says, this was given to me by the Dibrugarh police. Now, Lordship, under which law 172 CRPC forbids sharing of case diary with anybody? Now, here on oath, he is saying it has been given to me by the police. How can I accused have it? My lords have the entire records of the Dibrugarh case. Enough is not the word for this accused. Each and every sentence uttered is wrong. He has attached 11,40,000 bill spent on repairing my excavator. Lordship, I accept that they were paid. Now he did not pay the GST. This court should ask him to pay with the penalty. A person whose gazetted income is 80,000, it is there in my petition. How can he spend 25 lakhs? And that too in Itanagar, he says 40 lakhs. Shifting legal stands. This is the petition in Itanagar bench, Lordship. He has summarized it at 40 lakhs. The entire episode, including the payment to police.
Anyway, so main thing is that we should not, okay, and if you understand the background, you have gone into this thing. But we'll focus on this IA, we'll focus
Lordship,
whether his anticipatory bail should be cancelled on the ground of not conducting the proceedings with clean hands. That's the main, right?
Absolutely.
So I don't think it will be possible for you to complete today, right?
Lordship,
Because other matters also.
it's done.
No.
Just as
You may need time. I cannot force you.
No, Lordship,
But,
within 10 minutes.
2:30 we'll move to the other matters.
In
right?
10 minutes, if I cannot complete, I will seek a next statement. Lordship, these are the few Supreme Court judgments which I'd like to place.
Yes, you can submit.
Because these judgments will be common in the other IA also. Because that also prays for cancellation of bail. Now, Lordship, the first judgment I have cited is 1994 1 SCC 1 SP Shengalvagaya Naidu versus Jagannath deceased. Judgment or decree obtained by fraud to be treated as nullity and can be questioned even in collateral
Yes,
proceedings.
well settled position, yes.
Now, Lordship, we may come to Bilkis Yaqub Rasul, the famous Bilkis Bano case. Lordship may kindly come to page 173. Para 41.
173.
Lordship. Bilkis Yaqub Rasul, writ petition 491 of 2020.
Page 173.
Lordship. I have given the entire judgment, Lordship.
Yes, yes.
We are of the considered view that the writ proceedings before this court is pursuant to suppression and misleading of this court and a result of suppressio veri suggestio falsi. Hence, in our view, the said order was obtained by fraud played on this court and hence is a nullity and non-est in law in view of this. My lord can come to para 42. It is tried that fraud vitiates everything. It is a settled proposition of law that fraud avoids all legal acts in SP Shengalvarga and Naidu versus Jagannath, which I have just quoted before. Now my lords can come to para 43, the next page. The last line of the para, that an act of fraud on court must be viewed seriously. The next para, further fraud can be established when a false representation can be made knowingly. Second, without belief in its truth. Third, recklessly, being careless about whether it is true or false, while suppression of a material document which amounts to a fraud on court, suppression of material facts vital to the decision to be rendered by a court of law is equally serious. Thus, one, it is held that there was a fraud in judicial proceedings, all advantages gained as a result of it had to be withdrawn. In such an eventuality, doctrine of res judicata or doctrine of binding precedent would not be attracted, since an order obtained by fraud is non-honest in the eyes of law. My lords, may come to page 177, lordship. 43.4, lordship. A division bench of this court comprising justice placing reliance on the dictum in SP Shengalvarga and Naidu held in Ramkumar that a judgment or decree obtained by fraud is to be treated as a nullity. My lord may also visit page 238 on the same matter. Now my lords may kindly come to Himanshu Sharma versus State of Madhya Pradesh. Page 9. Para 12.
Yes.
Law is well settled by a certain of judgments rendered by this court that the considerations for grant of bail and cancellation therefore are entirely different. Bail granted to an accused can only be cancelled if the court is satisfied that after being released on bail, the accused has misused the liberty granted to him. B, flouted the conditions of bail order. C, that bail order was granted in ignorance of statutory provisions restricting the powers of the court to grant bail. Point 4, which is applicable to our case, or that the bail was procured by misrepresentation or fraud. In the present case, none of the situations exist. My lords may come to Ramadhar Sahu. Now, lordship, this is the case which was the accused's case. The court cancelled his bail. He came up for a fresh bail petition, and the court said under 362, I will not review your bail. The court has held in page 2. The High Court referred to section 362 of the Criminal Procedure Code, the said provision this and such and such. The opinion of the High Court in the impugned order is that in the event of the High Court granted bail to the applicant without compliance of the conditions specified in the earlier order of coordinate bench that would constitute modification of the order, the court prohibits such modification. Now, lordship, when you grant a bail, you say you cannot revisit to cancel it. The court cancelled, you came up for a fresh hearing for a new bail. The court said it doesn't apply. Vice versa.
Yes.
The Abdul Basit judgment was relied upon by the accused. Now, lordship can come to the first page. In the instant case,
Abdul Basit judgment.
Lordship.
Okay.
It's the lordship?
Yes.
Lordship, the first page.
Yes.
There is a mark D. We go another 3 lines. In the instant case, cancellation of bail was not sought on grounds that the bail was obtained by the petitioner by gross misrepresentation of facts, misleading the court and indulging in fraud. What they have cited is not the matter here. They have cited Abdul Basit saying the court is barred. Abdul Basit says this case is not of misrepresentation and fraud. My case is fraud. So Abdul Basit is in my favor, not in his favor. Had Abdul Basit been ordered on fraud and misrepresentation, he would have a case.
Yes.
Abdul Basit is not on misrepresentation or fraud played on court.
Okay. Get your point.
Lordship may kindly come to the next judgment, Ajwar versus Wasim and another. Page 19. Para 27. It is equally well settled that the bail once granted ought not to be cancelled in a mechanical manner, However, an unreasonable or perverse order of bail is always open to interference by the superior court. If there are serious allegations against the accused, even if he has not misused the bail granted to him, such an order can be cancelled by the same court that has granted him the bail. Now that 362 gone, this court says even if you have not misused your liberty, the same court can cancel the bail. Lordship may kindly come to the next judgment, page 1. It is Kusha Taluka versus State of Odisha. The third paragraph was
Just a minute, just a minute.
when an attempt was made to deceive the court and interfere with the administration of justice, the litigant was held to be guilty of contempt of court. It was a case in which husband has filed fabricated documents to oppose the prayer of his wife seeking transfer of matrimonial proceedings. Finding him guilty of contempt, he was sentenced to 2 weeks imprisonment by the court.
Yeah, it could be criminal contempt also.
Lordship. Now, my lords may kindly come to page 6.
If proved. Page 6.
Page 6. The maxim suppressio veri expression falsi, that is suppression of the truth, is equivalent to the expression of falsehood, gets attracted. We are compelled to say so as there has been a calculated concealment of the fact before the revisional court. It can be stated with certitude that the accused respondent tried to gain advantage by such factual suppression. The fraudulent intention in writ large is writ large. In fact, he has shown his courage of ignorance and tried to play possum. The next paragraph. The High Court, we have seen, applied the principle where infrastructure collapses, the superstructure is bound to collapse. Now, Lordship, the infrastructure is the false document in the bail petition and superstructure is the bail. When your pleadings go, the orders goes.
Yes. Okay.
The High Court, we have seen, applied the principle when the infrastructure collapses, the superstructure is bound to collapse. However, as the order has been obtained by practicing fraud and suppressing material fact before a court of law to gain advantage, the order cannot be allowed to stand. One more judgment, Lordship.
No.
It's Vikram Bakshi, page 17, Lordship.
Para 17?
Page 17, Lordship.
Page 17.
The last 3 lines of para 30.
Okay.
Such an attempt to alter review is not also feasible or permissible through a reference to section 482 of CRPC for being expressly barred under section 362. My petition is under 439 Lordship.
Yes.
Para 31, this court, however, in exceptional cases have carved out limited scope for exercise of review power by criminal courts. In Grindlays Bank Limited Supra, it was observed that review can be distinguished between procedural review and substantive review. A procedural review is inherent and implied in a court to set aside a palpably erroneous order passed upon a misapprehension by it. However, a substantive review is when error thought to be corrected is one of the law and is apparent on the face of record. It is in the latter sense the court held that no review lies on merit unless specifically provided under a statute. 439(2) is the statute under which I have come to this court. I have not invoked inherent or extraordinary jurisdiction of this court.
Yes.
The last paragraph can also be relied upon, Lordship.
Of this same judgment?
Lordship.
Yes. From Bakshi.
These were a few judgments, Lordship, which could I
Yes.
gather because they are all latest judgments,
Yes.
24 and 25. in the affidavit of opposition, may I have another 5 minutes of my lord's time?
Yes, sure. You can continue. 5 minutes you complete. Even thereafter, if you need.
No,
We'll fix
since others
another
are
day.
also waiting, I will.
No, no.
Okay.
Yes, that is my answer.
Because lordship, when it flows, let it complete at a particular
Yes, yes.
stretch, so it doesn't
That
get
is true.
affected every day.
True.
Now, lordship may kindly come to the affidavit of in opposition filed by the accused in this case.
No, I'm putting it. Affidavit in opposition filed with the accused. It
Lordship,
should be here in the same file. I
Yeah,
think.
it is page
Running
213
page.
onwards.
203.
213, lordship.
213. I'll find it. It's a running page.
Yeah.
I'll find it.
I need my.
That is it. This set of counter affidavits start with page 219.
Lordship, I have been provided one which starts with 213, lordship.
213.
It's written over here, lordship. 213.
Stop
213 is the index, lordship, if it is there.
210. And 211, 212.
Yeah.
Hmm?
Control.
200, yeah, I think. Yeah, must be the index. They've calculated it from there, I think. Index.
Lordship. Now, lordship, as I first pointed out, the FIR or the case was registered under a person called AB.
Mhm.
The anticipatory bill was filed by ABC.
Mhm.
Now the affidavit is filed by AB again.
Mhm.
Now he has a third father here. I don't know how do they gather the courage to play such a fraud on this school. Total impersonation, lordship. Now, lordship, may kindly come to page 221, lordship.
Two to one.
Lordship, very cunning case. That before adverting to parawise reply, the answering deponent begs to bring on record of this honorable court the relevant facts of the case, leading to the filing of false FIR by the answering deponent. Now, lordship, answering deponent is the accused. He accepts that he filed a false FIR against him. Lordship, we can come a few lines down. 1, 2, 3, 4.
Yes.
The fifth line from bottom. The answering deponent repeatedly assured that his machines were in good working condition. The accused says the machines were absolutely in okay condition, no damage or no repairs required. Now this is a contrary stand to his anticipatory bail. My lords can now come to page 224.
Just a minute. Two 24, right?
Lordship. Para F. In his anticipatory bail, he said excavators are not working. Here in the opposition, he says they were perfectly working. He said in the anticipatory bail, I abandoned them with the caretaker. So, lordship, once I leave this courtroom, how can I know what happened behind the scenes after I left? Here he tracks the excavators after he has abandoned them. That it was also found that the manager, caretaker and others were also cheated by the petitioner and he had failed to pay their salaries and dues. Therefore, the manager Badang Logo, along with the police help, seized the excavators. In the anticipatory bail, you say that I voluntarily on my own abandoned with the caretaker. Here you say they were seized by the police. The Mariang police white certificate such and such handed over 2 excavators to Kashing Gondir, who is another associate charge sheeted by Arunachal police facing trial.
No. Anyway, so.
Lordship, I will not take much of a time. I will just stress
Yeah.
some. I just missed out one thing, Lordship.
You conclude for today, then just
Lordship,
finish up.
I will not take much of a
Yeah,
time. Lordship.
close it and conclude for today, and we'll keep it for another day, right?
Lordship can kindly come to page 220, Lordship. I will just close with this.
Not necessarily your submissions, but for
Lordship,
today.
here he is saying that this is a review petition and it cannot be allowed.
Review petition.
His statement on page 220.
Mm.
In page 241, he says this is not a review petition. The various grounds already adverted by this honorable court while passing the fee-based bail arrest order cannot be relooked under the grab of the present application, which is not an appeal and review application against the bail order.
Mm.
He has taken the time of this honorable court to be charity.
Yes, I mean, it cannot be a review in disguise, but it has to stick to the jurisdiction of bail cancellation.
Lordship, I am not even too deep into that. In page 220, you say, I cannot go for a review. Here you say this is not a review application. What sort of a pleading or submission is this before this court? This case has taken 27 occasions before. So the loss of the judicial time can be calculated, Lordship. And this person is on bail on first document since 2019. Each time they come up with a lucky date, 3 months adjournment,
We'll
4
look,
weeks
no.
adjournment, nothing.
We'll look into it. We'll look into it.
I hope, my lords, I don't need to place any further judgments of
No,
the apex court on the matter.
This is sufficient. This is sufficient. I will also do my research. We always do.
Lordship, I have a humble.
And the other side is also there. So if they want, they can always place some judgment. in their
Lordship,
favor.
the
They have a
issue
right
is
to-
that this is with regard to 799.
Yes.
Now 665.
Mhm.
He is the recipient of 2 of the excavators.
Mm.
In his first anticipatory bail says, I have nothing. His bail is rejected when we produce documents that he has won.
Mhm.
He is not arrested with a direction by this court.
Mhm.
He files a subsequent one saying that I learned from this court that I have won.
Sure.
It is a submission in the petition.
That second IA, it is this IA, right?
665.
665. This is also for bail cancellation.
Lordship,
This is also.
extended hand of the prime accused.
Okay.
And his bail has also been cancelled by the Itanagar bench for suppression of fact. I will be placing that judgment also.
Oh, okay. Another day. We'll,
Outright at the motion stage, it was thrown out.
nice. I'll look into it. Anyway, so should we close for today? No? Okay. Okay. Just a minute. Wait, don't make me so vulgar.
This is totally abuse of the process of law. If you don't have time, you should not accept the brief.
Just a minute. Don't be agitated.
It was.
Just
Lordship.
the Lord.
I consider.
I just take it a khali likhi loga. IA 799 of 23. In disposed of AB 2355 of 2019. It will, sorry, not before me. This is, so the Manish Kumar Agarwal, the learned petitioner and person, appears and argues this matter. Also relies upon some case laws. I will not take your argument as completed in 799. It's completed. Completed. Okay. No. Parthard is different, but your side is completed with a right to reply. He concludes his arguments, but with a right to reply. Full stop. Your good name, please. P. Borwal, Learned Counsel, appears for the respond number 2.
In item number 56, your 799.
You are for the other case, right?
Yes, madam.
This is it will do. Criminal petition 558 of 2024. This matter could not be heard today due to paucity of time. You're appearing in this as petitioner. P. Borwal, Learned Counsel, appears as one of the learned counsels for the petitioner. IA Criminal 665 connected. IA Criminal 665 of 24. Manish Kumar Agarwal, learned counsel, learned petitioner and person appears But this argument will take another day.
Lordship, if my lords allow 665, I will complete the arguments within 10 minutes.
No,
Lordship.
no, no, let us.
Not today, Lordship, maybe tomorrow, day after.
Yes, another day.
Because
This
the
will not be
learning,
heard due to paucity of time. We'll hear it in another day. And IA criminal 195 is something else connected.
that is related to 665.
Way to petitioner in person. Okay, that's all. We can throw it out. That might be some side order to. Now we come to the date. You know,
Okay.
when would you prefer?
Can it be on 6th of February?
Lordship, why
No.
6th of February? Let it be after 10 years.
No, no, no.
You want to enjoy bail? Let it be up to infinity.
No, I'll finish it.
Let it be urgent final die. What is the problem?
I don't know. I have not started hearing, but this will be part heard. IA criminal 799/23.
Lordship,
After
it
the-
is shameful that they are avoiding to face this court.
No, no,
It should be recorded.
We'll fix it.
They should be shameful that they chose
No, no,
today's
don't-
date and they've come to for February.
Don't get agitated. You know,
Absolute
just see,
property of law.
no, don't get agitated. See, don't,
Lordship, it pains.
see, don't quarrel. You can oppose, you know, you address the court.
Lordship, something,
address
something
her.
at least
This
minimum
was,
should be.
you know, during my practice is one
Lordship,
judge.
apologize. with
No,
the-
nothing.
Can you
nothing
take
about-
submission
see,
faithfully?
Nothing apology. During our practice, you know, we one of the things we learn is that we don't argue within ourselves. We address the court. She has a right to make a prayer. The prayer of the council may be unreasonable or reasonable. The court will consider.
The
Court-
majesty of the court is supreme,
You
and
can
here the
consider.
majesty of the court has been maligned by them.
Court will consider. You let the next date be one of the dates within
Lordship,
within
please
this month.
kindly allow me to complete.
Within this month.
Lordship, I have a very humble prayer. I am the petitioner in 799. Lordship have heard me. I am the petitioner in 665. Lordship may kindly hear me tomorrow or day after, and then Lordship can hear that.
You don't take
Because I
the
have come from Calcutta just for placing my
2 days. I'll be on leave. actually,
Lordship
because of
can
some-
take it on Thursday even. I will be here. I will make my submissions in 665. And rest I leave it to my lords to make a.
Tomorrow there's some difficulty, and next 2 days I'll be on leave because
Lordship,
of some, you know,
any-
unavoidable some.
To my lord's convenience, I will not take a measure 10 minutes more. I will just complete in 665. Because my lords need to show how these petitions are being filed playing fraud on this court.
Will you finish in half an hour?
Absolutely, Lordship.
So Friday, Friday at
We can keep it to Lordship.
no, sir, keep it. We'll take it in the first half only.
Lordship.
Get that please going. First half. Huh? No, first half. Yeah, 10:30. 11. No, but first half. Or 11:30, something of that sort. How about, can you wait till next week? Then it can be very comfortable. And 8 or 9th at 2.
Lordship, please pick it on Friday. If it is not so, I will wait the next week. Just keep a tag, Lordship. If my lords don't have time, I will not pray for it. I will keep it on Monday or Tuesday.
Monday I could have fixed it at 2 and
So
taken
you
it
can kindly
comfortably.
take it on Friday. If my lords have time, lords can hear me.
My Kenya Prime work on it from Milan Judicial Academy program to একদম time constraint হয়ে আছে এখানে এখানে আমরা করলে ফার্স্ট আবার 10:30 থেকে ভুল হবে না ও ভাই I can fix it at 10:30 in the morning, huh? That way you finish it within half an hour. Then you can go back. Friday. This part, since he wants to argue on this.
Lordship,
Otherwise on Monday, Tuesday.
Lordship, I have to take instruction.
You
immediately.
take instructions. Otherwise, given a choice, I would have liked to fix it on Monday or Tuesday. Tuesday, preferably at 2. I would have preferred, given a choice. Because
Okay.
this week I am myself having some constraints, my personal.
Lordship, we can try it on Friday. If it is there, fine. Otherwise, Lordship can take it anyway.
Just give me
Yes.
5 minutes.
Otherwise, you know, madam, don't worry, your side also. I mean, even if your senior has some problem, he can, like today, he can address his part and then we can keep your part later. You take instructions.
Okay.
But so if you're not agreeable on Monday or Tuesday, keep it on Friday, 10:30. Because second half again, I have some uncertainty.
I will not take much.
Otherwise,
of
I
time,
would have fixed
Lordship.
it at 2.
Lordship, I have already addressed the court with judgments. I have just to prove the fact.
So, after the mention, you start
Lordship,
and try to fold it up by 11.
Lordship, Oblige lordship.
Since it has, as you said, it has come 27 times, so therefore I am giving it priority. Finish it.
My sincere apologies for any misadventure.
No. You worked hard on your file, being not a lawyer. Sometimes one knows, one's case very well. Sometimes it happens.
Lingering since 18, we are at the end of 25.
Anyway,
But
but,
investigation
see,
going on.
I have that's my basic job, with an open and the fairest of mind possible, humanly possible. I look at both sides but the only thing I assure you, both sides, show you petitioner that, because of many things beyond our control sometimes, because of this date listing and all that, but we'll finish it. We'll finish the matter. We'll finish the matter.
Oblige lordship.
And kindly take instructions that since it's court has said that since it has been pending, it doesn't look good from the point of view of docket also. You can also see it like that.
Yes,
That, I'm not blaming you or anybody, but there is that docket also, it does not look good. It's been, IA has been pending for 2 things. So, court, you tell your senior that the court has expressed, desire that we can, so, you can close the issue, complete the matter, dispose it of. Right. I'll keep the judgments.
Lordship, it's
Timing joke.
Timing item 22.
May I please, Your Lordship?
Yes, sir. This was open, this matter, no? Yes.
Lordship.
Your junior colleague had appeared. This matter, yes.
Notice is not there, Lordship, in the record, but Lordship, we have filed our objection.
Mm.
In objection, we annexed 48 notice, Lordship.
Also.
Yeah.
It's there. But in the record, it's not there. But you have found it. It is there in the objection. Okay. But I don't know why this bail was given then, the earlier bail. This is the same bail where
Yes, Lordship.
at that time it was not found, no?
Bail was given on the ground of Lordship 47 notice, Lordship.
47 notice.
Yes, Lordship.
But in case of this petitioner, 47 is available.
47 is available, but there is no grounds for arrest, Lordship.
Achha, achha. Okay, that one. Anyway, let me have a look. Put record. Record. What is the record? When will Mr. Kyle be available next?
9th of December, Lord.
9th of December. Can you wait a few days?
Lordship, otherwise Lordship had granted interim also to the accused, Lordship,
Because-
on perusal of the notice, Lordship. Other two accused, Nur Safi and Sarif Sesam, Lordship. And later on, Lordship made their bail absolute, Lordship.
That order is there.
Yes, I have given, Lordship, now. No, sir.
I've forgotten slightly, anyway. The mind also gets, from jumping one matter to another. Anyway, that's our job also. So you're saying that this memorandum of arrest, it narrates some details. Memorandum, it has some details. There is a Kakkar case that memorandum of arrest can also suffice if the grounds are, there, provided it fulfills the criteria of, it cannot be given, it cannot substitute for 47 per se, but if the contents are there, it can meet the requirement of substantial compliance. If the contents are okay, then it can meet the requirements of substantial compliance. That was in that Kakkar case. It was, I used it in one bail petition. Per se, this is not sufficient. 47, this is not sufficient. But 48, you said 48 is not available.
Not available in
Here.
this record, in
Okay.
trial court record.
Okay.
But we have filed our objection. In
Mhm.
objection, we annexed 48 notice, Lordship.
Also-
It is there.
So I can see the objection then. It will be best to see the objection.
Lordship.
Because only if things are black and white, then only I can consider interim. Otherwise, we'll have to wait. Because these are otherwise very serious matters, right? 22C. Intimation of arrest document, no, this one. See, the name is doesn't matter. 48 letter might be absent, but if the intimation is there, it is informed to the relative, then it might suffice. We cannot be completely, impractical also. Ra Devi, wife of Vasant Thakur, so and so, narcotics has arrested one person. Arrested one person, Vasant Thakur, in connection with seizure of so and so. It is not complete non-compliance, but
Yes,
some more, no, it is not a case of complete non-compliance, but some more details are also necessary.
But
This I would say prima facie, seizure of so and so tablets, but from whom?
Yes,
This kind
Lordship.
of things.
Even in this.
But I think, again, but this is more detailed, little memorandum of arrest.
Lordship,
This is
even
more
this
detailed.
present case, Lordship, nothing was
So
recovered.
and so, they've written something, so and so vehicle, it was suggest from so and so, and then based on voluntary statement recorded on the 16th, I place you, this has some details.
Lordship, in the 47, Lordship, they are not given, Lordship, and the intimation of arrest also, Lordship, the details not given, Lordship. It was seized-
47 notice is blank, but the memorandum of arrest, accompanying memorandum of arrest, as I just said, that is that judgment. I don't remember the citation now. Accompanying memorandum of arrest, it is not, it cannot be said to be completely bland. It has some details. Whether it is sufficient or not is, it will be interpretation in the facts of the.
Otherwise, Lordship, in the 47, in the 48, Lordship, intimation of arrest, Lordship, intimation of arrest, in the intimation of arrest, Lordship, the from whom it was seized, it is not given, Lordship, which is required, Lordship.
Anyway, that maybe you have a point, but I think it will be better, it will not be, I think I will not be comfortable to give interim because though it's really placed, because there are some questions of interpretation also. So let him, let Mr. Kyle appear. You just wait for a couple of days. It's a serious matters. Eventually, if you get bail, that is also would be a relief for you.
Lordship, if Lordship, the scan copy is, if the scan copy is not complete, then the complete scan copy may be called for,
It
Lordship.
is complete.
No, Lordship, at that
Complete that's all.
scan copy. not-
And we can use this week for that also. Update the scan copy. In the meantime, he will come. Council, Mr. Thakur, placing an order dated 26/9/25 passed in BA 3160/25. Submits that the present petitioner is also on similar footing.
Lordship, I have placed, Lordship, another bail
Yes,
application.
yes, Shakir.
Shakidul.
This was placed by you.
Yeah, I have given, Lordship, but I am on same footing of Shakidul because nothing was recovered from my possession also.
Yeah.
Shakidul also, not from his possession. It was from possession of Nur Safi and
Can
Sasef.
you kindly tell me the bail number of that?
Lordship, bail application
Submitted.
4152025.
You gave me the just order.
Yes,
I
sir.
don't know where I kept it.
I can, Lordship.
No, you gave me, I don't know, I kept it inside or, I don't know, anyway. BA number so and so,
415 of 2025. Lordship.
that he is also on similar footing as there has been non-compliance with the notices under 47/48 BNSS. M. Deka, Learned Standing Counsel, Learned Counsel appearing for the NC prosecuting agency NCB. Sorry, investigating agency NCB and representing SC Kyle, the Standing Counsel. Submits that an objection has been filed where these notices have been annexed and there is narration of details in the intimation as well as the memorandum of arrest. However, the Learned Counsel submits that the Learned Standing Counsel is outspoken and praised for fixing the matter. Should we fix it on 8th or 9th? 9th or 9th? So though the Learned Petitioner Counsel seeks interim bail, however, considering the fact that the compliance needs to be looked into and adjudicated, therefore I prefer to dispose of the matter finally, after hearing both sides. This is the matter on 9/12, talking to me.
Updated constable option.
Oh, yeah. In the meantime, the updated TCR comprising relevant documents will be called.
Obliged.
23, 33.
There's some miscommunication, I think. No, there's some miscommunication. We will fix it on another day. If there's some urgency, they will mention. I think there may be some miscommunication, I think. They have not appeared.
2333, because earlier order is there for surrendering the petition to surrender.
Interim has to be extended.
Yes, interim, there
Yes,
matter
interim is
on
there.
26/11/2020.
Interim is there.
Interim is there.
No, actually, here also it should be extended, actually. None appears on call AB 24, this is item 33, none appears on call, same. Good stuff. Diary was received.
Diary received.
Oh, diary is received and shall be retained. Interim bill stands extended till the next date of listing. Good stuff. List the matter on Monday. Can you keep it?
Otherwise, earlier a direction was there to surrender him on 7/11/2000.
Surrender or appear?
Surrender.
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 Where? Order dated?
Order dated 16/10/25.
Of 2447. AB 2447.
Yes.
Hmm?
In 3326, 23, my lord. And probably in all cases, my lord, there are 14 cases pending against the present petitioner, my lord.
Anyway.
Item number 23, he's the against him, my lord. 33 is his wife.
No, interim bill granted, not surrender. Interim.
Direction was there, my lord, earlier interim.
Oh, I see. Then now I remember. Now I'm remembering. Yes. Interim bail was granted and on that day he shall surrender. This was there. Interim bail was still 7.
Yes.
Thereafter nothing happened. Oh, okay. Why they are not appearing then?
Next date, my lord, immediate, next week, or Friday, my lord.
Well, otherwise this will become disjointed. Let it be extended. Huh? This interim has to be extended. It would be said. Interim will be extended. None appears on call. List the matter on. Don't take it on Friday. Please excuse me a few days, 1 or 2 days this week.
9/12, my lord.
9 or 8 also.
8/12.
8. Both the cases on 8. Should I write till we tag together?
Yes.
This
Same thing.
maybe tag together with BA 3326 or AB 2447. 3326 or AB 2447. These are same.
Timing 53, 53.
Wait. I've ordered. Oh, it's different. 23 and 33.
Oh, 53, my lord, same accused person. One in my lord.
Oh,
This is Bhangagor PS. my lord. Same accused.
they should have appeared actually, at least counsel. Anyway, the same date.
Then this matter may kindly, my lord.
Interim stands extended till it BA 3151. This need not be tagged with this. This is a different one.
That may be fixed on the same.
On the
day.
same day. That is FIR is same.
Yes.
Okay. Interim bail passed on 17/10/25 stands extended. Just a moment. Order. There's a mistake here. There's a mistake here. Those two are same FIR, tagged together. This is a different FIR, but same accused. Huh? We give it on the same day, but need not be tagged. So there's a mistake actually here. The interim bail stands extended till the next date of listing. This is the matter on 8/12. None appears on call. It. We have the admission.
Okay.
Criminal appeals.
Admission item 11.
May, just your lordship, lordship may kindly have a look the last order dated 15/10/2025.
Hmm.
By which the application on the strength of which the order dated 8/4/2024 was passed to deposit the 20% of the total check amount that has not been received. I have checked the record, my lord.
Mhm.
After passing of this order, my lord, there is no office note, my lord.
There is no office
Profit-
note. 20% was deposited that 148(2). 148 subsection 2, that's appellate court at the time of
No,
admission can deposit 60.
140, there is an application under section 143A.
Mhm.
And my lord, our
Interim compensation.
interim
I see,
compensation.
interim compensation.
And my lord, that application, it is not, it was not supplied to us, and moreover, my lord, it is not on record, my lord. So that's why, my lord, on the first occasion also, my lord, the.
Your litigant grant was directed to, he is the accused
I'm the.
in the NI case, and
NI.
then he was directed to pay the interim compensation of 20% of the check. amount,
20%.
right? You are the complainant, right?
So I have checked the record, my lord,
Against that, he has come.
my lord. So there is no office note after passing of this order. So probably, my lord, a fresh requisition has to be made, my lord,
Okay, we'll make the fresh requisition.
my lord.
Is there any latest Supreme Court judgment on interim compensation?
My lord.
I know this much that it has to be after the plea of guilt stage is passed.
My lord.
And that or charge explain someone's case, so offense explained or whatever, that
Yeah.
stays after that stage.
My lord. And my lord, there
But-
has to be a separate application under section
Application. There's
143.
another,
my lord.
yes, but therefore many reasons this has been done, these things,
Yeah.
because people are running helter skelter for, after lending money, he feels like he's the, guilty one, but then 20% deposit, but this is, there is some, it's a debatable provision
Right.
because the person is not yet adjudged guilty, right?
Yes.
So we other compensation we pay from DLSA, that victim compensation, not
Yeah.
from the accused. That sometimes we have to explain also.
Yes.
This is not from you because it's going on. But that is why the accused can always say, for argument's sake,
Yes.
conceptual, accused can always say that I am presumed to be innocent. My guilt is being decided by you. Then why are you asking me to pay?
My lord.
But of course, they have to file. They have to give a bond.
Bond.
Then they have to return.
Yes.
Just to
case of
actually
acquittal, they-
because of the very bitter experiences from the side of complainant that these provisions have been incorporated. That's why I asked, is there any latest decision of Honorable Supreme Court throwing more light on this issue? Anyway, Mr. Bosho,
A Hassan.
yes, learned counsel for the Petitioners Act, draws my attention to order dated 15/10/2025.
Lordship may kindly see the page 41, my lord, annexure 8.
So we'll call for
Page 41,
Hmm.
annexure 8, my lord.
Hmm.
Order dated 8/4/2022. Here it is.
that's okay.
So this petition has been called for, my lord.
Hmm,
On the strength of which this order of 8/4/2020 was.
Page,
called.
page.
Page 41.
Okay. This petition was called for.
My lord.
Yes. Order dated 24/10/2024. Scan copies of application dated 17/1/22.
My lord.
The order is dated 17/1/22. The application filed by the complainant side seeking interim compensation was called for. But it appears that the same has not yet been received. Issue
Received.
fresh reminder
My lord.
to procure from the learned trial court scan copy of the application filed by the complainant seeking 20% of the check amount as interim compensation,
Interim.
right? Under section
143A.
143A NI Act.
And I Right, order dated 8/4/2022, my lord.
The relevant order is order dated
8/4,
8/4/2022, passed by the learned trial court.
my lord.
That is Court of Learned CJM Kokrachhar. In, let us write that also. CRNI 3 of 2022.
My lord.
What is the interim order?
Interim, the operation of this
Mhm.
order has been stayed, my lord.
Interim order dated 10/11/25 shall continue in the next date of listing. You kindly work out a date, because all these things get, delayed. This is also 24, it should be quickly decided. This is, I think, one matter we can probably dispose of at the stage of
My lord.
admission,
Admission
perhaps.
stage, yes, ma'am.
So you take the date, when should I fix it? After,
My lord,
vacation?
there has to be a fresh requisition, so it will.
Yeah, fresh
would be-
requisition, fresh requisition.
My lord,
He wants fast, you may want a little relaxed. So after today is only, we don't have,
my lord.
we have only 21 days in this month. No, remaining month. Better, it will
But,
be practicable in
Can
January.
it be on 16th of December, my lord?
Let it be before Bihu.
If-
Let us fix a date if it comes.
January.
Just before Bihu, 9/1,
9/1.
9/1/20, Friday, 9/1/25. If it doesn't come, then we'll fix it
Well-
after Bihu. 9/1/2026.
Obligement.
Item number 12,
Jail appeals. For the format also, what is the way it is. The instant jail appeal has been preferred by convict Nogen Naik against judgment and order dated so and so, passed by the learned Session Judge Sibsagar, convicting him under section 326, 307 IPC and sentencing him to undergo additional PP, learned additional PP. K. Bosta appears. He may be furnished with a copy of the present of the relevant documents, including the impugned judgment. Impugned judgment has to be called for, I think. Oh, it's on the next page.
My lord, that PCR may be called for, and amicus may be appointed.
Yeah, I know that much. It has to be called for it. Call for the original case record of so and so. Sessions case number. Sessions case 46. 24 from Sessions Judge Hibahakar. After the receipt of TCR, necessary copies shall be furnished to the learned additional PP. They'll furnish you. And amicus has to be appointed. Your list is there. Division bench. You can also suggest. Yes, we are appointing mostly for bail. There's another one, eh? Two petitions are there. Two appeals are there. Surface notes. The necessary copies shall also be furnished to the amicus and his name reflected in the cause list. Next.
13,
My lord, this is my lord, that is the appeal filed by the my lord state, my lord.
State?
Yes,
I
my
see.
lord, against my lord acquittal, my lord.
Oh,
Now, my lord, already leave petition was filed before your lordship, and that is allowed. Now, my lord, we have one IA, my lord, that is for the delay condemnation, my lord.
just a minute. No, this is a criminal appeal,
My lord,
198,
My
State of Assam.
my lord.
I see. This is a criminal appeal against acquittal
Yes, my
filed
lord.
by the state.
Yes, my lord. The POXO matter, my lord.
Mhm.
Judgment and order dated 18/11/2022.
A leave is necessary. Leave.
My lord, leave part already completed.
No,
my lord.
why leave? So I might have forgotten.
Uh,
Leave is for criminal, is against acquittal in a complaint case.
My lord.
In this also it is necessary. Leave.
But that part was, my lord, taken, my lord. Earlier, my lord, that is, my lord, available in the
We have
record.
to refresh the basic concepts again and again. Sometimes, no, complaint case,
My lord, always there.
leave has to be, it is
My-
subject to leave,
my-
which is given if
my-
you make out a
my-
reasonable
my-
case. But state filing appeal,
My lord.
shall we check it once?
Yes, my lord.
It is under BNSS or CRPC?
My lord, CRPC, my lord.
Oh, earlier.
378(3).
No, the appeal is filed against under BNSS, I think.
My lord, no, my lord.
Maybe
it is, my lord,
BNSS. 25 appeal, no, it's BNSS.
Then, my lord,
378 earlier section 378.
yes, my lord. Earlier section 378, my lord.
But IA is for delay condonation.
IA for delay condonation, my lord.
Will not take time because I'm just waiting. Appeal against acquittal. 419 now.
Oh.
419. Kindly take it up. Let us clear it now only. Yes, 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 yes.
My lord, filed by the state, my lord,
Mm.
not by the victim, my lord.
Subsection 3.
My lord, subsection 3, my lord. 378, subsection 3, my lord.
Forgotten this section. That means leave is necessary for state also.
Yes,
No appeal to High Court. Can you read that?
yes, my lord. Only, my lord, that is para 3, my lord. That is the subsection 3, my
3.
lord. No
419
appeal to the
subsection.
High Court under subsection 1 or subsection 2 shall be entertained except with the leave of the High
Leave
Court.
of
my
the
lord.
High Court. Is necessary. You're right. Mm. Hmm? This way we'll not forget.
My lord.
The best way to remember something is to learn it by making mistakes.
So, my lord, it's for learning for us, my lord.
No,
Lordship.
no, I forgot. Always thought only complaint case. Anyway, so now there is a delay.
My lord, now we have that part of delay, my lord. For that, my lord, that is the IA, my lord.
We have to issue notice.
My lord,
Right?
my lord.
He will definitely have something to say, against acquittal.
My lord.
Even on the point of delay.
Yes, my lord.
If he can
Yes.
get it there only.
My lord, my lord.
The state of Assam / prosecution represented by the learned additional PP. K. Boyce is seeking to file criminal appeal against criminal appeal under section 419. subsection 1B. Read with 419 subsection 3 of BNSS against the judgment and order dated 18/11/2022 passed by the learned Special Judge POXO Morigaon in POXO case number 141 of 22, whereby the accused therein, namely MD Nazirul Islam, was acquitted. Not proof beyond reasonable doubt. Any order? There is no order with regard to leave. Is there any order?
My lord, there is another one file is my lord there.
The first
Along
we
with the
have to-
IA, my lord.
No, IA.
Yes, my lord. The one criminal
Oh.
petition for leave is there, my lord.
Okay. No, first let us
Yes, my lord.
clear the
Yes.
condemnation, otherwise
Right.
the question will not arise.
My lord.
In terms of section 419 subsection 3 BNSS, prayer for leave has also been made, giving rise to criminal LP 32 of 2024. There is also an interlocutory application being IA criminal 830 of 2024, seeking condonation under, which is by way of an application under section 5 of the Limitation Act 1963, seeking condonation of delay of 694 days in preferring the aforesaid criminal appeal against the judgment and order dated 18/11/22. Issue notice upon the respondent. It will be sent through registry, right?
My lord.
You will take steps.
We can also, my lord.
Steps may be taken. Whatever it is, steps of, just write this, notice, steps of notice upon respond number 2 may be taken. So let it come in the orders column next.
My,
This is the matter, the orders column. Let us give some time
my,
after reopening.
my,
When? Because we have the Vihu vacation in between.
yes, my lord. So my lord,
First.
before Bihu then, my lord,
Before Bihu or after that?
after that also,
Let it be after that.
after that,
21,
Twen-
21/1,
21.
2025.
My lord.
Six has about 700 days.
Yes.
He'll oppose strongly. The POCSO case.
14,
My lord,
Go on.
criminal revision petition, my lord, and pleadings are completed, my lord. So, my lord, after due, my lord, may be fit for disposal, my lord.
We can admit and fix.
Notice already issued.
Notice, it is there, is appear, but
Yes, no, I have appeared one.
My lord, just one thing, I want to take your lordship only page 90, my lord. Page 90,
still,
that is the order. Only till 11%, I am reading out.
Page 90.
Page 90, my lord. I'm just reading out the 11% for lordship kind convenience, my lord. In view of the above discussions and decisions, it is held that a petitioner, minor Sarkar, is entitled to maintenance from the opposite party. Priyanka Sarkar, and the maintenance is fixed at 20,000 only per month for the petitioner and her minor girl child, Anahi Sarkar. Since then, my lord, they have not paid any interim maintenance earlier granted by the land court below. And also, my lord, they have not paid, he has not paid any single amount. How can I survive, my lord? I have been running helter and shelter, my lord. And my lord, the appellant, the petitioner is, my lord, he is an inspector of this CRP. Only that much will help me, my lord.
Can you just repeat that? No amount has been paid,
No
right?
have been paid.
So what is, can you just
My
repeat
lord,
that?
my rupees, the 3 lakhs, my lord, was taken by her, my lord. She is kept in, my lord, she has kept in the, my lord, the fixed deposit, my lord. And one of my prayer is also till, my lord, adjustment of the date amount, my lord. At least she can get from that amount, my lord.
But it was followed the order.
It is admitted by them.
You must have followed the order of the court.
In the
You have
evidence,
followed
my
the
lord,
order of
it is
the court.
admitted.
That is a great concern.
Records have come, right?
It is admitted, my lord.
I have not admitted that, my lord.
No, it is.
I have not
have
admitted. It will come at the
enclosed
hearing
the
stage.
evidence.
That will come at the
I
hearing
have
stage.
enclosed
Now
her
at this
evidence also.
At the time at the hearing stage, but at this present.
Was, I'm just asking, it's okay, we'll come to
I
that.
only want, my lord, maintenance amount to be paid, my lord. Till now, they
My
have not
lord,
paid. Even the
my
interim
daughter, my
maintenance
lord,
are
I am
granted
paying
by
my
the
lord
court.
school fees
They have
extra.
not, I have not,
Fees all.
my lord, daughter, my lord, 8 years, who has been going to a school, my lord. I have not been able to fees the school fees.
pay something for the child. I mean,
My
of course, you
My
will-
lord, second, my lord, take
we
from
can
the
direct,
debt amount.
we can direct
It was
of
my,
course.
my amount, my lord.
to get some instructions, but we can direct also to pay him for something for the child. Usually that is not disputed. Amount may be less.
Can I place it before lordship or should I place it on the next date, my lord?
Submit.
My
Okay, I'll keep it. You have a copy, no? You have a
my
copy?
lord, I have got a copy, my lord. Page wise and far wise is given, my lord.
It'll be helpful. Okay. I'll keep it, huh? Respondents.
I'll also be on our Supreme Court based on stay also, my lord.
Here is the heard as Mr. S. Chauhan, learned counsel for the petitioner, and S. Roman, learned counsel for the sole, as I said, Roman, learned counsel for the respondent, sole respondent. Good stuff. The petitioner stated to be the husband is challenging the grant of maintenance in the impugn order to the respondent's state/wife and their minor child, quantified at rupees 20,000. Most of the scanned case record has already been received. You have filed an affidavit also? You have filed a?
Yes,
It appears that pleadings are also complete. It appears now, I cut it out. The respondent has also filed an affidavit in opposition. Stop.
And reply also filed.
And reply thereof has also been filed by the petitioner side. Let him pay a little amount to the child. Little,
My lord, 10,000.
3,000,
my lord, per
10,000 will pay.
per month.
Oh, very good. I was going to tell a little less only, but very good if he's paying 10,000. The learned, I can record that. No?
Email.
He'll not charge you.
Yes,
The learned counsel, Mr. Chauhan, clearly submits that during the pendency, the petitioner is agreeable to paying rupees 10,000 for the upkeep of the child, minor girl child,
but
the parties. That's the same. Then he'll pay from now. Let him pay from now for the moment. Later we'll resolve that, you know, because otherwise it will create complications.
my lord.
The said payment may be passed from this month onwards.
Yes.
Okay. Actually, these matters ideally, you know, should be actually admitted, but again, maintenance matters, I don't know. I am aware of the, you know, these things. I'm also learning. So let it remain at admission. Admission stays
Yes,
only.
my lord.
We'll try to dispose it of.
Dispose of, my lord.
Maintenance.
My lord, court sends
on a
my lord,
hearing
is
day.
Busy, my lord.
Yeah, but you know, all matters is not possible.
Yes.
But you know, that
Just after.
I do not have
bill, my lord.
a complete answer to that issue. I am also learning. So for the moment, this one be list the matter in the admission column itself.
After review.
After view, no
Should
problem.
we fix a date?
Yes, sir.
Man,
Very
man,
well.
Should we fix a
man,
date?
after view, man, no problem.
21/1, huh? Tuesday.
15,
May please, your lordship. This criminal appeal has been come for the first time after condonation of delay, your lordship.
Okay.
Uh,
There was a delay, it was condoned.
Yes, sir. So, the appeal has been filed assailing the impugned judgment and order dated 8/8/2024 passed by the learned additional session judge Jubilee, whereby the accused appellant was convicted under section 370 of IPC. So at this stage, your lordship, notice may be issued.
Yes, yes. We must have implemented the informant side, right?
No, your lordship, since the victim is major and
But there was I don't know whether there was an earlier notification because we used to follow it much before this Deepak Nayak, much before. There was a notification actually, actually not in a judgment, but there was a notification that in criminal appeals, the informant should be implemented. But I don't know whether it still subsists. But we used to follow that. Many times we used to follow.
As per my knowledge, your lordship.
It is not compulsory.
Yes.
Yes, this is not compulsory, I think.
Yes.
But
This is a
the way victimology is progressing, now, it's a matter of time when it becomes, if you want, you can issue notice if you want. But the appellant sometimes may not want, because, it strengthens the prosecution if the victim also comes. He may not want for his own good reasons. But, so I'll not put the burden on you. So if I direct, or otherwise it will remain like this. You could name, please?
Miss S. Jane.
Learned counsel for the, yes, everyone. S. Jane, learned counsel for the petitioner, appellant. The criminal appeal under 415(2) BNSS has been filed against impugned judgment and order dated 8/8/24, passed by learned additional session Judge Dhubri in sessions case number 349 of 2018, whereby the appellant been convicted under section, only one section, 370 trafficking IPC, and sentenced to undergo social liquidated.
Paper book is required to be prepared. Paper book is
I
required.
will come to it. Always helps, but if they can prepare, nothing like it. The third learned additional PP, K. Boysa learned additional PP for the state. Copy we furnished to the prosecution. So for the moment, we are not issuing notice to informant, right? For the moment, if later on point, if you want, you can tell. The appeal is, the appeal being a statutory first appeal in criminal law against conviction is admitted for hearing. The call for the case, the original case record of so and so, sessions case number, additional session Judge Dhubri. Good stuff. He was sent 7 years, no? He must be in custody.
Yes.
Okay, that I will take up later. We'll see later. We'll see later. In fact, that I have thought about this actually. That criminal, of course, the logic is the same, but in a POCSO IA against suspension of sentence, it's not required to issue notice to the informant.
That is very much.
That is required. But in here also, he may have something to say.
Yes.
On his liberty,
Might.
something to say.
Might.
But we'll see. We'll cross the bridge when it comes to. But it is not it is not mandated by any law as of now. But we cannot compel them because they may have their reasons not to.
My lord, from the point of what my lord has stated regarding the point of view of victimology, my lord. that-
Criminology and this no, I'm severe. Ordinary, this Supreme Court has said in some recent issues that now we are reaching a time, or we have reached that time where the victim will be given a locus standi at every stage from bail till. Oh, what else you said? We call for the records, original records. That's all. This is the matter in the orders column on so and so date. When should we fix it? Suggested good. Or we can just give a list in the. Let us leave it to registry this time. Like, 3rd week of January.
3rd week, yes, sir.
3rd week of January. This list in 3rd week of January on a date to be fixed by the registry. Some dates we should leave for them. They can fix harmoniously.
16.
Obliged.
Yeah.
So, Lordship, appeal against conviction, Lordship. Earlier, delay was condoned, Lordship.
How it
It is
more or less something.
appellant convicted under section 51 of the Wildlife Protection Act, Lordship, and
Yeah.
sentenced for a period of 7 years.
Yes, yeah.
My lord, in this matter may kindly be time being, because my lord, if it is a wildlife matter.
Yes,
then my
Mr.
lord,
Sharma will appear.
Forester help karabe, very.
But we can admit the appeal.
Yes.
Admit
Yes,
the
sir.
appeal.
And then-
I don't know, criminal appeal. Against judgment and order dated 13/6/25 passed by learned Session Judge Baksa, Masalpur in special WLP 12/18 within bracket arising out of Goreswar PS case number 29/16, whereby the appellant was convicted under section 51 of the Wildlife Protection Act 1972 and sentenced to undergo RI for 7 years and fine of 50,000. ID SI for 2 months. He can probably fill in. The prosecutor can represent this informant. I think.
Yeah, my lord, in this case, we can represent because my lord, it is a my lord, my lord, that the FIR lost before the police station.
Yes.
Not as a complaint.
Yes, yes.
So we are representing them.
Also, you can represent. Okay.
Yes.
The as the case was filed before the police and investigated by it, and therefore the learned additional PP represents the prosecution and also the respond number 2/informant. Copies be furnished. Bill is admitted. Call for the original case record of special word from Session Judge Baksa.
Lordship, there is the idea.
I will take up. We can take it
After
up.
my lord receiving of the my lord this year, my lord.
That will be
We need
better.
to go through and my lord, some extra copies may also be provided to
Yeah,
us.
extra copies be furnished to the
Both my lord, I and my lord. Yes.
for the petitioner. This is the matter. When should we fix it?
And it is after my lord.
Third
this is
week,
the reopening,
uh-uh.
after third week,
In the month of January,
in the
on a
month of
date to be fixed by the registry. The
A date may fix, Lordship, otherwise he is in custody since the date of the judgment.
price 22, 1.
All right.
Take this also, same date of one. I 4:30, no, invoking 4:30. This thing. The interlocutory application has been filed seeking suspension of sentence and bail with regard to impugned judgment dated so and so. Okay, stop. Notice the prosecution and the respondent police and the respondent number 2/police official represented by learned additional PP papers. So extra copies be furnished. Full stop. The original case record has already been called in the criminal appeal. We'll take up the IA after receipt of records. Is it okay? The IA shall be taken up for adjudication after receipt of the case records. Original case records. List the matter on along with the main criminal appeal on 22/1/2025.
All right.
Just 2 minutes break. I'll take. Come.
Listen. Admission is the order. Admission with this.
Please take your seat. My break only.
Item number
Next.
17.
16. Okay.
Yeah, my lord, petitioner, my lord, both the appellant, my lord,
Same. no?
convicted under section 411 IPC, my
I
lord.
see.
My lord,
Sentence to?
for receiving, my lord, stolen property. My lord, there is no proof in the case, my lord, that what is stolen. And nobody, my lord, they claim or file any FIR or that it was stolen, my lord. 4 cars were recovered from a vehicle, my lord.
No.
And an open vehicle, not it was hidden. My lord, a small truck, my lord. And my lord, I have gone through entire, my lord, evidence. Nothing, my lord, nobody can, my lord, say that it is stolen property. And in fact, my humble submission, not a case of conviction, my lord. Anyway, my lord, since it is, my lord, convicted and imprisoned in 3 years, my lord. And 3 years, my lord, I have filed one IA, my lord. And in conviction of 3 years, my lord, our High Court, my lord, used to grant bail, my lord. So, my lord, I pray for granting bail, my lord. Praise bail,
You
my
can
lord.
definitely pray. Should we look at it now or after receiving the
My
records?
lord, in 3 years, my lord, cases, no, my lord, if it is, my lord, more than 3 years, then after receiving. In other cases also, cooperative benches, my lord, granting bail. But after 3 years, my lord, at the first instance, it can be granted bail, my lord. My lord, I can.
First, let me admit the appeal.
Yes, yes.
Yes, form for the heard as Chauhan learned counsel for the and K. Boyser for the prosecution. The respondent number 2 being a police official, respondent number 2/informant being a police official can be represented by the prosecutor, additional people. Right, Mr. Boyser?
He's the informant, yes.
You can represent him, I think. Yes.
Right.
No, no,
My lord.
you can represent him,
My lord.
police official.
My lord.
Appeal under 415 BNSS against judgment and order sentence. Common 1310 format. And sentence, order of sentence dated 1610. Passed by law.
That's are there, my
Yes, yes.
conviction is 1310
Yes.
and sentence is
Yes,
1610.
that's always better. But anyway,
Yes.
we always, many cases, visually have same day. 131025 conviction and sentence dated 161025. Passed by learned session judge Udalguri. In sessions 2, case number 62 of 23, whereby there are 2 appellants. The 2 appellants for their were convicted under 411-34 IPC and sentenced to undergo
3 years.
RI for 3 years.
Last person, my lord, 3 years.
The appeal being a
In appeal, my lord, page 31.
statutory first appeal against conviction is admitted for hearing. Full stop. All for the original record of Cohenford from home court of Udalguri. Extra copies may be furnished to the prosecution.
Yes, my lord.
Please the matter in the orders column on if we are considering it after receipt of records, then I will fix
My
it
lord,
before Bihu.
Our practice, my lord, in the High Court, my lord, if more than 3 years, my lord, then it is.
Yeah,
a
I know,
record.
that's true.
But that is why I am pressing,
More
my lord.
than
And
it's
then
actually
also
below 3 years, up to 3 years is
Yes, up to 3 years.
the court can give bail. I mean, the convicting court can also bail
Convicting
for a
and
limited time.
Petition, my lord, it was rejected.
They
Yeah,
filed,
no.
my lord, in page 32, my lord.
No, I
There is a-
admit that we filed petition, not
But
granted.
on that, they stated that, my lord, on perusal of the judgment dated 13/10/2025, it transpired that the offence are of different and continuing in nature. The convicts were
How it is
sentenced to suffer
continuing in
3 years
nature.
RI, my lord.
Because we have to give an opportunity to the prosecution to
My lord,
make
my
their
lord.
say. Right?
Short date, my
Keep
lord.
it next week then.
My lord,
This will, because otherwise it will be, this will come again.
my lord,
Because this cannot be fixed next week.
my
We
lord,
have to fix it just like that.
my lord,
Okay.
my lord.
This is the matter on, you suggested it next week. It will come just like that.
My lord.
In the orders column. The orders column on so and so date.
This
Next
is the last part of the December, my lord.
Last one.
Okay, 18.
Yes.
And this one on that day.
Oh, yes, my lord, my lord.
I on that day,
Yes.
on 18th. I would prefer it, if you keep it that week, I would prefer it towards the earlier part because last 3 days, the
Right.
last 3 days of that last week,
That is
should
possible,
keep it,
my-
keep it light.
Then, my
Yes,
lord,
we should not fix
before
nothing
that, my
else.
lord.
If you take it in that week, 8 to 12, that one,
Yes,
that
ma'am.
week,
Yes, ma'am. Any date, ma'am.
If it can be taken.
12, 12,
Yes,
12.
12.
But
Invoking for 528, that's seeking suspension of sentence dated 16/10/25 passed by so and so, sentencing him to copies be furnished to the prosecution. Correspond number 1 and 2. The main record has already been called in the main case, main appeal. So okay, this is fixing it on this date means that we can dispose it of without the records.
My lord.
Main
meaning-
records.
meaning there. My lord, in the meantime, my lord, record may be called for,
It
maybe
not-
we may.
I'm calling, but it,
Yes, ma'am.
it may not come. Udalguri. Okay. Since the sentence is, then we'll see.
Yes, my lord.
It's on the basis of impugn judgment. Now we cannot go into merits.
18,
After appeal against conviction, your lordship may kindly submit the appeal and call for
Yes.
the trial protocol.
NDPS.
Judgment, your lordship will find at page number 1.
No problem. I get whatever. Here also, I think you can perhaps, the informant is likely to be a,
No, that is not required because in IA number 1186, which is filed along with the application,
Mhm.
by the order dated 6/11/2025, the notice upon respondent number 2 was waived. So
wait,
therefore,
no, he
yes,
can represent in any case. It's
yes,
not necessary because
therefore,
the police
notice is not
officer.
required.
I cannot put it on the criminal appeal. Judgment and judgment and order dated B/2025 passed by special judge Karbi Anglong in NDPS 89/22, convicting the appellant under section 21B/20B2C NDPS Act and sentenced to, he was sentenced to this 10 years, no, minimum 10 years. Suspension of sentence in NDPS commercial quantities is almost a very tough call because
No, I have not
no, I'm not saying.
have not filed
No,
any
no,
IF.
you have a right to seek it. You have a right to seek, but
I
because
will
of-
prefer that.
which is the judgment you preferred? Mentioned this Hira Singh. Hira Singh. No, not Hira Singh.
Here in fact.
Dadu, I think. Where remission, everything was removed. No? Remission, all removed. Remission, no suspension of sentence, everything was removed by the law. Then it was constitutionally challenged. Then it was said that you cannot do away with remission, everything completely. Suspension of sentence completely. So it was partly held to be constitutional, partly. So said that still no remission in NDPS cases. I didn't know it once upon a time. No remission in NDPS cases, in the jail. And suspension of sentence, said it was removed. So court said yes. Altogether, if you remove it, it will violate 21. But you can suspend the sentence, but you have to follow the mandate of section 37. So after framing of charge, it is difficult
No,
to apply 37. And after conviction, how will you say 37? No?
I do not have a good case at all.
I have not dealt with that in actual practice, but we should also study, Sometimes we should do some of these cases also to delve, how to apply it.
Lordship may fix this matter in the month of February or March, because we'll go for final hearing.
Yeah,
Because I'm
these are
just
meant to
disappointed
be
that-
heard like that, actually.
Yes.
Where bail is tough, we mean to speed up. Unfortunately, that's not happened. So list in the first week of February
Lordship.
on a date to be for the actually second week. First week of February on a date to be fixed by the registry. If it gets late, you make a mention.
Lordship.
Hmm.
Obliged.
But you look up the law. I think that is Dadu. I think that Dadu. Hira Singh is different. Dadu versus state, I think.
19.
Criminal.
Made please your lordship. Appeal against conviction under section 8 of the POCSO.
Okay.
Sentence is of 5 years.
5 years.
There's also an IA for suspension lordship.
We'll call for the records
Yes.
and then examine it, right?
Notices may also go there.
Oh, this notice will be necessary in this cases. খালি একে মই কৈ দিওঁ কোনটো পাৰ্ট কৈ দিওঁ heard so and additional PP for the state for response number 1. Appeal under 415 to BNSS against judgment and order dated 1/10/24 passed by learned Special Judge Morigaon, POCSO case number 201 of 22, whereby the accused appellant was convicted under 8 of POCSO Act and sentenced to undergo so 5 years. Steps of notice upon the response number 2 shall also be taken. And, call for the original case record of so and so from the post record. Extra copies be furnished to the additional public prosecutor. Lisa, when should we fix it?
We'll fix that. Lordship, sometime in January. Suspension.
Last week of January, to a date fixed by the registry. If it doesn't get listed, you make a mention. And the IA is filed invoking 430 for suspension of sentence and bail with regard to so and so. Record has already been called for in the main appeal. Steps of notice upon the respondent. Here, she's the victim. Yeah.
Yes, Lordship. Victim.
But name should not be mentioned.
There is a oversight.
Let me just
Yes.
redact. List in the last week of January. on a date to be fixed by the registry. On identity, actually, this is also, identities, usually we, like, I'm not saying anything, generally I'm saying that because otherwise, how do you issue the notice? Because otherwise, see, I am say X, but if you write my father's name, my locality, then I'm Nipun Saxena says it should not be identified, isn't it? Small village, suppose, she's a so-and-so, suppose X, daughter of so-and-so, a student of so-and-so school in a village, so you can be, the identity has to be protected actually. So name is one part of it, but there are other parts also. But at the same time, how do you,
Maybe
Hmm? Hmm?
my lord, in that part, my lord, some
No,
new mechanism
no,
maybe there.
no, Nipun Saxena already,
Right.
the Honorable Supreme Court, which is the leading case on this Nipun Saxena, this has already been that the hiding of identity.
Right.
Identities, our name, we have our identity is just not our main thing is name, but we have other identities also, right? So you should not be identifiable that you are so and so to protect privacy and dignity. So that's the thing. But if you say XY everything, son of XY village, resident of Y village, then how will you send the notice?
That part, my lord, some mechanism may be developed, my lord.
20,
Publish.
Appeal against conviction under section 8 POCSO Act, along with the application for
Yes,
suspension
a
of
lot of
conduct.
criminal appeals today. Huh?
Yes.
They need to be admitted. To be admitted. Same other law. If it's not a matter boss. Okay. Judgment dated 3/7/25 by learned Special Judge Dhemaji, POCSO case number 26 of 2017 under section 8 of POCSO Act, rigorous imprisonment 3 years, fine of 8,000, so and so. That's Harvata section. Read with section 440 IPC. Call for the original record. Last week of January will do on a date to be fixed by registry. If it gets late, you make a mention. Let's get the record. Suspension of sentencing. Last week of January on a date to be fixed by the registry. This is 5 years. 5 years.
No, so this is 3 years.
3 years. Okay.
3 years he is on bail, right?
3 years. Okay. He was on bail.
Bail.
Okay. Now he is in custody.
No, now he is on bail.
Oh, so he's on bail.
Bail.
Then IA too, there's no IA then.
Is for continuing the previous bail.
But then we'll have to pass an order.
My lord, because my lord, as per my lord,
It'll expire.
Performance, my lord, notice is required, my lord.
After notice, lordship can
Yes, my-
extend it perhaps, but the time frame.
What is the language given? Then it will be till. Learned code below. Where's the bail order? Is it there?
No, lordship, bail order is not, I am not annexed.
Not the next. But he'll be on bail, no?
Yes.
Till must be written like this to enable him to order obtain orders from the appellate court, something like that. I don't know. And to suspension of sentence and to remain on bail during the penance.
On petition number 982/2025, dated 3/7/25. The order was passed.
Okay, the petitioner, the convict applicant is stated to be on bail at present. By order dated
3/7/25.
passed by the trial/convicting court in petition number
982/2025. Obliged.
21,
That is the lordship. Lordship, this is an application made under section 528 of the BNSS 2023 for quashing and setting aside the charge sheet as well as for quashing of the trial proceedings initiated against the petitioner in PRC case number 727/20, corresponding to GR case number 3306/20, pending before the learned Court of Additional Chief Judicial Magistrate, Barpeta.
Okay.
The respondent number 2, they have filed an affidavit in opposition.
What are the sections? 366A.
Yes, yes, Lordship. Lordship, the FIR at that time was filed by the victim's father out of aggression, and at that time both the victim and the accused, they were minor. So after that, the marriage was solemnized at the
After they became major.
after they became a major, then they have also kid out of that wedlock.
Yeah, that is the only problem. She was a minor at that time.
Yes,
And the
yes.
charge sheet was submitted under 366A or 366?
366A.
And 366A is actually you are for the informant. Yes. Prosecution is also.
Allegation is minor, that is 366.
Yeah, 366A is actually that section for penal provision, the police. Nowadays it has lessened, but though they give it, whenever it's a minor, it's for to prevent child prostitution. You know, but the thing is that 363 could come if she's a minor. What is the FIR? Can you see the FIR? Much time also.
Page 11.
Page 11.
11.
Translated. 16 years.
16 years.
How old was the accused? Just asking if you have the information, in case you have the information. Because that is also a relevant factor to determine these things sometimes. 16 years. The court has come. I said it. Order sheets are not very helpful actually. What we need is the.
Order is there, 6625, my lord, page 22, my lord.
Where is the charge sheet is there?
It is there, my lord. It is in my lord, page
Page
20, my lord,
20.
that is the Anacono form.
Oh, this is the earlier format charge sheet.
Yes.
Could you translate it? Because I won't be able to read this. I won't be able to.
18, my lord.
Oh, you have taken the pains to translate. Brief, thanks.
But my lord, here, my lord, in the my lord, first sheet, my lord, the 164 statement is mentioned. The statement of the victim, my lord. My lord, in their case, my lord, my lord. So my lord, my lord.
Charge sheet
the
was submitted
record,
under which section? Same section
my lord.
or different section? It's not mentioned. It must be mentioned. You must have missed it. ROTO 366 AM. victim statement is here,
But not available.
not available.
Not available. So in this case, my lord, we need the my lord record. My lord. Because my lord clearly state about her 164 statement, my lord. And the my lord.
I say, no, this, sometimes the order sheets, some order sheets may not be helpful.
Yes, my lord.
Main thing is that we need the case diary, charge sheet.
Sir, and my lord, the status of the case, my lord. Same time, because my lord, in the order sheet, my lord, there is the order dictates, my lord, 6625, my lord. For the side, my lord, for even. Very next. Appearance of the.
Appearance. Well, let us get the statement. Huh? We'll get the statement. That will be because it will be necessary to. Otherwise, you are not objecting. They've settled the matter. You file additional affidavit also. Sorry, affidavit also. No, addition. Affidavit. Recording no objection.
Kindly may the proceedings be set aside as because they are leading a conjugal life. So they also have a kid, who is 6 months at this stage. So it will be a very difficult situation because the father is the sole breadwinner.
You're privately engaged counsel, right? Not amicus, because sometimes amicus don't have instructions, right? But you have instructions. They've settled the matter. What do you say? So it's not much time.
At
also
this
there.
stage, my lord, it is because, my lord, they are in the appearance stage, my lord. And my learned friend submitted that, my lord, there's a next date is fixed on February, my lord. So before February, my lord, a date may be fixed. In the meantime, my lord, there is the search sheet along with the CD may be called for. Because, my lord, in the CS, my lord, it is categorically stated that victim girl's statement was recorded under 164 CRPC, my lord. And after conducting the medical checkup at so and so, the report was collected.
But
So
lordship,
these are
at
the
this-
my lord materials, my lord. At that point of time, my lord, what is my lord? And regarding my lord respired, so my lord.
but
I think, my
lordship,
lord, there will be
lordship,
before that if it is fixed, my lord. And
But
no
lordship,
NBW, VWA is issued, my lord.
Yes, tell me.
yes, although the victim girl's statement was recorded at the stage, at that stage, but at this stage, they are already married, lordship. So she have no objection as they have a kid.
It's from which Barpeta?
Barpeta.
It is time I can, if I dictate, no other matter can be touched.
Marriage certificate and birth certificate.
Mhm. No, the easy part is that he is also appearing. That is
Yes.
because otherwise private counsel. Otherwise, we can take a view. Otherwise, we can just call for the 164 statement and fix it next week.
But that can also be done, my lord.
Because of time constraint. Otherwise, I'll have to dictate very quickly because otherwise nothing will be there.
164 and my lord, if possible, my lord, there is a CD.
Huh? CD.
CD. Both of the section, my lord, otherwise not good. Lord. Because FIR is not very much clear, my lord, at that point of time.
No, they have
That might also, my lord.
affidavit.
That probability is also there, my lord.
Which
But only the, my lord, because what my learned friend.
Well,
submitted.
they were also-
Yes, ma'am. That part may be also there. Only the thing is that at that point of time, as per the FIR, the age was my lord 16 years.
16 years, 16 years, that's true. But it will take time now, if I dictate. And I have already piled up, no time inside. So. Quickly, huh? Criminal petition 1145/2025, invoking 528 VNSS. The petitioner, sit down. Faridul seeking quashing of criminal proceedings being PRC number 727 of 20, corresponding to GR number 3306 of 2020, pending before learned additional season Barpeta, and stated to be at the stage of appearance. Full stop. And the father of the alleged victim girl had lodged an FIR dated 23/7/2020 before the Sorbuk PS with the allegation that on 20 in the afternoon, the named accused kidnapped his minor daughter, aged 16 years. The case was investigated and the case was registered as Sorbuk PS case number 130 of 20 under section 366A IPC. The investigation resulted in a charge sheet against the accused under section 366A. And the case, it will be pending for committal, actually, pending before the learned court below, as stated, as already stated. It is stated and submitted on behalf of the heard, and the pursuant to issuance of notice, the respondent number 2/informant entered appearance to learned counsel. M. Alam. Prosecution is represented and filed a affidavit supporting the prayer of the petitioner. It is it is stated and submitted on behalf of the petitioner side that by way of subsequent developments, the petitioner and the alleged victim girl were in a relationship, though at that time she had not attained majority, and that later the family stopped, and after she attained majority, their marriage was solemnized, and now they also have a child stated to be aged around
6 months.
6 months. Copy of birth certificate and marriage solemnized under the Muslim law has also been annexed. Copies of documents. In this circumstances, the petitioner is seeking quashing of the criminal proceedings. Third, learned additional PP. The learned additional PP submits that perhaps the statement of the alleged victim girl recorded during investigation may be perused, which is not available in the scan record receipt list. Mr. So-and-so learned counsel for the informant supporting the evidence affidavit on, it will not be an affidavit enough for this is the affidavit. But what else do you say? Affidavit states and submits that the informant states and submits to Gatido does not dispute the contentions of the petitioner side. Full stop. In para 3 and 6, the informant has stated that in the meantime, his daughter, after becoming major, was given in marriage to the petitioner, and they are leading a peaceful conjugal life, and a male child was born to them, who is presently aged 10 months. He is also supported. He is also you have annexed, or he has annexed?
He has annexed.
So this is he has annexed copies of the marriage certificate dated 10/1/2024, solemnized under Muslim law, and also a copy of birth certificate dated 4/1/25 regarding the child. Full stop. It is specifically stated in para 6 that he's not inclined to pursue this case, and therefore come before this court with this affidavit. Though at the time of the alleged offense, next break, I've considered the materials and the submissions on both the sides. At the time of the alleged incident, the girl was admittedly a minor. And the penal provision given was section 366A IPC, which criminalizes the act of kidnapping a minor to force into illicit relationships. Good stuff. The charge sheet was also filed under the same section. Despite the aforesaid circumstances being on the serious side, it cannot also be overlooked that the alleged incident took place in the context of a relationship, love affair, relationship/love affair between the accused and the heard. How old is the accused? I'm not backtracking, but just want to know. So, but 34 years. Oh, last word to keep on.
Not 34, 34.
Relationship between the accused and the girl. Good stuff. The subsequent and present developments about the petitioner and the accused and the petitioner and the girl getting married upon her majority and leading a conjugal life along with a 6-month-old child cannot be overlooked. Good stuff. Next paragraph. In the given facts and circumstances, allowing the prosecution to proceed apart from being a futile exercise, apart from being an exercise in futility, may not also be in the best interest of the family, especially the child. Accordingly, in the given facts and circumstances and in backdrop of the above discussion, the so-and-so proceeding, so-and-so stands quashed. Petition stands allowed and disposed. No case lost. No time lost to write. Anyway, should we go for the mention? What the matters left? 15 minutes. Or anything very urgent, you can tell me.
Milords, may I mention item number 42, Milords? Milords can hear me?
Oh, you startled me almost.
Milords, I'd been following you, Milords, for a long period of time, so I've been it's a one-side participation, Milords.
It's okay, just joking.
Milords, it's a quashing petition of the quashing of the charge sheet, Milords.
Just hold on, I'll come to you. Should we make it I think it will be better, no time. I'll come to you.
So, senior colleague is online, your lordship. I'm appearing for the complainant on behalf of the senior colleague that is online from Delhi.
So we could do, just a minute, 21, right? So,
Since your lordship.
just a minute, don't worry, we'll do the mentions peacefully and comfortably. I'll address all of you.
Yes, Milords.
Senior date, your lordship,
Just hold on.
can a service be done for
Just,
the?
I'll come to you. Itu amar admission tamne kitaman yato loiso. Supply loro. Aru orders supply. Okay. Tell me now.
Lordship, item number 46, in the morning, we have prayed for upgradation of the matter.
Upgradation, right?
So Lordship, kindly, it's a delay matter, Lordship, orders criminal appeal, accused is behind the jail, Lordship. So I pray to take up the matter because on the last occasion also it was not reached. So it's second.
58, right?
56.
46. File with the option.
46. Right.
Delay in criminal appeal.
Yes, Lordship, only 42 days, Lordship. So that may be condoned, Lordship, if the prosecution has no objection, Lordship, because the person is in jail, Lordship, since the judgment 9/7.
Just had a look on this.
Only 42 days delay, Lordship.
$376.
Yes, sir.
But so I think this is notice has to be issued. No, she is impleaded. Informant is impleaded, but 376 case. That is not mandatory.
Mandatory.
So we can condone the delay. Condone the delay. Yes, it's a right. It's a fundamental right. Fundamental right, almost against conviction. One appeal is a fundamental right. So it I mean short appeal like this. I will not dictate. Not a dictate. So we'll condone the delay.
Highly
Condone the delay and admit the appeal. No? Appeal.
TCR, Lordship.
They are my notice maybe.
Oh, we'll issue a notice. Since you are made party, we'll issue a notice. This will condone.
My lord, in
I
respect to
discussed
item,
appeal chamber.
may it please your lordship.
Just a minute. Otherwise, we'll have to, we might make mistakes otherwise. I'll come peacefully one by one. Tell me.
My lord, in respect to item number 42, my lord, there was a
42.
previous order been passed by the honorable court that
Mhm.
the interim prayer will be considered
Mhm.
upon the service,
Right.
service being made and
Mhm.
upon the next date of hearing, my lord.
Right, right.
My lord, the service has been already been made and
Filed.
my learned friend for the respondent number 2
42.
has filed a
Lord,
vakalat, has appeared.
No,
That service may be deemed to be completed, your lordship, but we need to have a legible copy of the.
yeah, and considering the interim, I think it will take a little bit of while adjudication.
Yes, my lord, that's why they are due to.
Lord, it has to be heard, my lords, before interim order has to be passed, my lords.
15.
Your lordship, my
Interestingly,
senior colleague is appearing online for this
Yeah.
matter itself.
Yeah.
If he can be entertained.
Today it won't be possible.
no, my lords, only 30 seconds which I wanted to say, my
No,
lords.
nothing is possible. in
Fine.
this.
My lords,
Don't mind. Surely hear
my lords,
you.
they may be directed to supply me a fresh copy, my lords, because the
Hmm.
half of the petition is not readable, my lords.
Okay, that's okay. That's sorry. I thought that because that is okay. He has already your local council. He has already submitted nicely on that. So let it be.
Yeah. My lords.
I don't have an interim prayer and in the lower court, in the trial court, the matter has been fixed on 15th. Can it be taken up on 12th, my lord? And last to date, there has been paucity of time. Can it be fixed on 2 p.m., my lord? At 2 p.m., my lord, on 12th.
My lords, have it
Can
after
be.
the vacation, my lords, after the holidays, my lords.
It is on 15, my lord. May grant me interim protection until that date, my lord. Then I do not have any issue, my lord. That if a stay may be granted.
My lords,
only-
interim can't be afforded, my lords, without hearing, my lords. It
In
is
that-
not,
No,
their
no,
personal
I-
liberty is
it can be
curtailed.
fixed before that, before 15th, my lord. On
My lords,
12th.
he's already on anticipatory bail in this matter, my lords.
My lord, still,
Oh,
I
you are
think
on-
it's a criminal proceeding.
And then nothing to.
12th, my
My
lord.
lords, what is he to fear, my lords? I don't
It's a case,
understand.
my lord.
He's on an anticipatory bail. The charges have not been framed, my lords.
It doesn't matter then. Nothing much to worry. A few days here and there won't make much of a
Yeah.
difference.
My lord,
You're on
anytime
bail.
after
My
20,
lord, that is there. The matter is in the trial court. The matter has been fixed on 15th,
Mhm.
my lord. That's why I'm praying. I have an interim prayer, my lord, on the stay of the entire criminal proceeding, my lord. There has been non-compliance of section 173(8). My entire case is based on that, my lord.
my lord, if he has to argue on merit, I will argue, my lords,
Exactly, my
without
lord.
even the
That's
file
why I'm
also.
praying. My lord, senior counsel, Mr. Kamal
Paucity of
Agarwal will
time.
be appearing.
No, I won't be able to, others will get delayed. Paucity of time. Today, let's the matter.
Sometime in January, my lords, please.
My lord, 12th of December, my lord, on 15th, it is matter is fixed. Senior counsel, Mr. Kamal Agarwal will be appearing in this matter.
Your lordship, and the service also may be recorded in the. Your lordship.
My lord, I need to file a
Yes,
reply
entered
after going through the
appearance.
petition, my
On
lords.
behalf of respond number 2.
Yes.
You have entered appearance on respond number 2.
Indeed, your lordship, as well as the counsel who's appearing online is for respondent number 2. We need a copy, your lordship. The legible copy needs to be reflected in the order.
His good name,
Vikas Gupta,
Vikas Gupta and
AM Burma.
M. Bora, learned, Vikas Gupta, learned counsel appears through online mode from Delhi. Learned counsel, A.M. Bora appears in person before this court. They may be furnished a fresh copy, fresh legible copy as prayed for. full stop. The petitioner counsel reiterates his prayer for interim protection, submitting that next date is fixed on 15/12. That's the problem actually. Without hearing, we cannot give. At the same time, date is also there. But one date, if you can manage, what is it fixed for?
Milord, nothing is happening on that date, Milord. Nothing is happening.
You're on bail, no?
Yeah, he's there on anticipatory bail, Milord.
No, you're on bail, isn't it?
That is there, man.
Then
My lord, my learned friend will let me submit my lord.
Lord, all I am praying is, my lord, all I am praying is, my lord, all I am praying is, my lord, if it can be fixed on 10th or 12th, my lord, senior council will be appearing in this matter, my lord.
not possible. Thereafter, no, next date, what is the difficulty? Tell me. You may have some difficulty.
My lord,
but
I have an interim protection, my lord. I am praying for
No.
interim
Suppose
relief, my
you're
lord,
on
on this.
bail. So if the matter is you appear.
Yes,
There is an
definitely,
interim
my
protection,
lord.
your lordship.
I do
Appear
not.
and you make your bail, submit bail bond and make it regular. And then you tell the court that our prayer for interim in that criminal petition is pending. And
Lord, may
because of
kindly consider, all I am praying, if
Why?
it can be fixed on 10th or 12th.
No,
my lord, all I
why?
am
Because
praying.
see, we are so
If your lordship
constrained.
may consider granting interim state will violating my 21, my lord, because this is a frivolous proceeding been initiated against me, my lord. Total frivolous proceeding, my lord.
There is a frivolous proceeding, my
Milord,
lord.
without the petition,
Why
it's
the
going
lordship
on and
may
on and
consider-
on.
My lord.
It's on bail.
Proceeding
My lord, that
will
the
also
lordship
have, my
consider-
lord,
that's
something.
why I'm
Unstoppable,
praying.
my lord.
Happen, my lord. It is a case, my lord, the frauding in the name of, my lord, one autonomous council. Thereafter, my lord, by way of that, they're fraudulating everything, my lord.
Milord, the petitioner is a
That's the
con.
case, my lord. More and more.
He has ample number of
All
cases
I'm asking is
against
a
him
date,
in
my lord. All
Karnataka,
I'm
Milord.
asking is a
Both the
date, my
husband
lord.
and wife are con men of the South, Milords. Milord, I'll show and demonstrate that how, Milord, the entire
What is it?
defense has been made as a ground for
No, if you are
quashing,
on
Milord.
bail, there's
I don't
what
know
is
what
the
is
major
the
apprehension?
petition is this,
One
Milord.
date, only one date.
One date, my lord, before 15th, my lord.
How can you please be reasonable? See, I would like to accommodate everyone, but we have constraints, right?
Any date, my lord, before
At this
15th.
pile of pending judgment, I'll not go home now. I have so much work.
And that is being fixed for appearance. There is no effective thing that is going to be taking place in the lower court itself.
3rd of January.
Milord,
My lord.
can you-
It can
Pardon
be
me,
fixed
Lord?
before December, my 15th of December, my lord.
Milord, he's asking as if he's been threatened to arrest or something. Milord, please have it in
I've not
January, Milord.
understood his apprehension. Anyway, 15th of
15th.
December. Since you are insisting, okay, let us 15th of December.
My lord,
Milord,
Indian council is
some
having a little
difficulty.
difficulty
And
on.
I'm asking, Milord. That's the only difficulty. Milord, please have it in
No, leave it to the
anytime in
registry.
My lord,
Leave it to the registry.
The prerogative itself changes.
Then
After
my lord,
vacation, my lord.
My lord, then
After
15th.
vacation.
My lord, then 15th. I'm
After vacation, your
Milord,
lordship.
I don't even have the copy with me, Milord.
You need your lordship.
He'll need a copy.
You
right?
need your lordship.
I'll provide that, my lord.
15 days will be less to provide. They have a lump sum of.
Milord, I'll even file
Milord,
my
15
counter
15
also. Milord, I'll file my reply also. He has
Just
filed a
the
340-page
voluminous
petition
application,
in a
above
quashing
300
petition.
pages. We
I
need
need to
time
file
to
my
reply.
reply, Milord.
600 pages.
344 pages, your
No,
lordship.
you can have electronic, anyway.
And we need a
I'll
time. to
provide the
study.
soft copy, my lord, and hard
Your
copy. as
lordship,
well.
legible. It has to be legible.
Milord, I'm not available in December. That's the reason I'm requesting, Milord. No heavens will fall, Milord. The case has been pending for last 2 years in the trial court.
List the matter after 2 weeks. After 10 days, on a date to be fixed by the registry. I'll leave it
Fine,
like that.
Milord.
I cannot
Fine.
decide. I'm confused.
Yes, my lord,
So
item number
please,
48.
they will decide. They will have. They can also decide. They can decide. You can tell them also that this is our difficulty. They will work it out.
Item number 48,
Or
Lord.
registry.
Item number 48.
48.
Lord.
Highly obliged, Milord.
I think I lost my was list also.
Item number 48.
48. Yes.
Kindly
Yes.
date may be fixed after vacation. My
Yes,
minute from here.
Okay. Interim, what is there?
No, Lord.
This is the matter.
A date may be fixed.
In the month of January, let us leave it to the registry. If it does not reach list, you make a mention. Don't worry. It's not, things have changed now. Electronically, it's done.
Yes, sir.
List in January to be on a date to be fixed by registry. 38.
Item number 30.
I will take it 1 minute. 38.
The criminal review petition, my lord, the order which they have challenged, my lord, the impugned order already complied with, my lord. They have This is the certified copy of comply.
Okay, then we can fix it next week and close it.
My lord,
My lord, I am appearing on behalf of the petitioner in 38.
Uh-huh.
my
My
lord,
lord, we have challenged.
they have compliance certificate already, I have.
Okay, you
We have
dispute
chal-
that.
Yes, ma'am. We have challenged the validity of the order itself. Learned magistrate has traveled beyond jurisdiction, my lord. That is our claim. Though we have complied as there is no stay order, we are directed to hand over keys of a gate. We have given as there is no stay order, my lord. But the validity is still under challenge. And they have, my lord, they have filed 2 affidavits in that revision petition saying that we have not complied with. That is also part of the
Some
record.
dispute is there.
Yes, my lord. I need to file a counter to that. Lordship will fix it after 2 weeks. In the meantime, I will file my counter because they have alleged violation.
My lord, up to 1 week.
List after 10 days on a date to be fixed by registrar.
Item 49, maybe, my lord, item 49. My lord, matter is listed, my lord, I made a mention for urgency because my lord, the stay order is against us, my lord. We are for the respondent. So maybe taken Thursday or Friday, most urgent case, my lord. The maintenance is state, my lord. We are for the wife, my lord. With the child, my lord, item 49. So the entire maintenance is stopped, my lord. And
Thursday.
Thursday, my lord. All right, lordship.
May please, your lordship. May please, your lordship. Item number 36, there is a leave petition, my lordship.
36,
36, leave petition.
leave petition. 36.
Appeal is not a raised.
It's a private appeal,
Yes.
appeal against equity. So today paucity of time, so we'll fix it after.
Give a date, my lordship.
You can service,
Main appeal is not registered.
not yet raised.
Hmm.
Filing number, no? Sure. Against equity, against equity. So let it be
Then
after vacation, after vacation.
after voting,
List in January, the date to be fixed by registry. Against equity, right?
May I please, your lordship? Well, at item number
If
51.
any date.
But they will fix it. They will fix it. It will come. If it doesn't come, we'll make a mention. It will come.
Item 51, lordship. This is against the closure of DW, lordship. And the matter has been fixed on 22/12/2025 for argument. There is no stay, lordship. May I pray, lordship, this matter may be taken up on 16, lordship, 12.
On 16th,
16,
1/6,
1/6/12, lordship.
16.
December.
Lordship, I beg to mention item number 37, Lordship. Lordship, this is appeal against conviction and delay condemnation application was listed, Lordship. Notice was issued. There is a delay of only 11 days, Lordship.
Is it?
And petitioner is, the appellant is behind the bar, almost it about to complete a year, Lordship. Delay maybe at this stage, Lordship.
Other matter, what is your?
My lord, item number 39, my lord.
14.
My lord, since 2022, my lord, the appellant is behind the. My lord-
22.
Yes.
22.
No, item number 39, my lord.
39.
39.
Yeah,
No, date may be fixed, my lord. Because it was, yes, I for bail, my lord.
Jail. IA criminal is for?
My lord,
For suspension of sentence.
suspension of sentence, my lord.
Jail, it is a jail appeal.
Yes, my lord, actually, earlier this case was
Jail
handled by,
appeal.
yes.
Then you, and it was engaged.
We entered, my
No
lord.
issues. Okay. This will. Criminal appeal, no, I is 25. We have to fix a date, a paucity of time to. Okay, when, this year or immediately after reopening?
This year, my lord, because since one third sentence already passed, my lord,
I see.
behind, yes.
I see. Which section, conviction?
376 and section 4 of POCSO, my lord.
Notice has to be issued, no? Notice.
Already issued, my lord. Amicus curiae has appeared, my lord.
Appear
Yes,
also?
yes.
Then we can fix a date, perhaps. Any other date?
Any date?
15.
Convenience? 15, my lord. Highly obliged, my lord.
And this matter, your matter, let me see. Yeah. Come.
37.
This is a POCSO. POCSO, notice is there, notice has been issued. Because the delay is only 11 days.
My prayer is to condone the delay and let it come in appeal for admission.
He was convicted for
Convicted for.
5 years.
Yes.
So, yeah, can you, what to do then? It should be.
That's a delay.
Return, yeah, just, that's okay, and because we are just looking at the procedure. So will you take instructions?
Deepak Nath, my lord, is
Uh,
very clear, my lord.
Will you
have
take
to issue notice,
instructions?
my lord.
Will you take instructions?
No, we can take it in my lord.
Because notice has already been sent, I think. Oh, take steps of notice. Have you must have taken steps?
Yes, yes. Yes.
Steps, we must have taken steps. That
We
means
take
there
instructions
might
from
be a
either
notice
notice
not
or
also.
servo not, my lord.
Oh, it is steps, so in AD card has not yet received.
Not
No, you take instructions. Fix it next week and we'll take it, he'll take instructions. You take the instructions, we'll fix it on Thursday. No, Thursday. And see, the thing is that the criminal appeal for 11 days, POXO, 5 years
Yes.
complete, it has to be condoned.
Yeah.
We have to complete the procedure.
On fourth, my lord. On fourth, Thursday, fourth.
No, not this Thursday,
Oh, my lord, okay.
next week.
Okay, my lord, 11, 11,
On 11.
11.
Can it be on 10?
No problem.
On 10. Okay. Obliged.
আর হয়েছে পুরিল
ইয়ার পালো, ইয়ার পালো।